hear instruction on how the public may access Spanish interpretation.
Thank you. Good afternoon.
Recording in progress.
Good afternoon. We're offering live interpretation in Spanish during this meeting. If you wish to hear Spanish interpretation, please click the interpretation button at the bottom right corner of your Zoom screen. You will see a globe icon. If you're joining via the Zoom smartphone app, select your language by clicking More or below the three dots in the bottom right corner of your screen. Select Language Interpretation and choose Spanish and click Done. If you wish to hear only interpreters and not the original speakers, be sure to click Mute Original Audio. Buenas tardes, estamos ofreciendo interpretación en vivo en español durante esta reunión. Si desea escuchar la interpretación en español, haga clic en el botón Interpretation, que significa interpretación, en la parte inferior derecha de su pantalla Zoom. Asimismo verá un icono de globo terráqueo. Si se está uniendo a través de la aplicación Zoom para teléfono inteligente, seleccione su idioma haciendo clic en More, que significa más, o en los tres puntos en la esquina inferior derecha de la pantalla. Seleccione Language Interpretation, interpretación del idioma. Después elija Spanish y haga clic en Done, que significa listo. Si desea escuchar solo a los intérpretes y no a los oradores originales, asegúrese de hacer clic en Mute Original Audio, que significa silenciar audio original. Thank you, and back to the commission.
Thank you. Before we call the meeting to order, we will have Ms. Blankenship, the city clerk, administer the oath of office for our new commissioner.
Thank you so much. Okay, please raise your hand and repeat after me. I state your name.
I, Erica Gonzalez,
Solemnly swear
solemnly swear
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
that I will well and faithfully discharge
that I will
well
and faithfully discharge
the duties upon which I'm about to enter.
the duties for which I'm about to enter.
Okay, congratulations.
Thank you.
Thank you.
Okay, let's call this meeting to order. Welcome, Ms. Gonzalez. And let's start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, looks like roll call's next.
Yes, I will take roll call. Vice Chair Lexinger,
Here.
Commissioner Feiger,
Here.
Commissioner Imhoff,
Here.
Commissioner Williams,
Here.
and Commissioner Gonzalez.
Here.
All present.
Thank you. Okay, we will start with public communications, and this is anyone in the public's opportunity to speak about any agenda or item not listed on today's agenda.
Thank you, Chair and members of the Commission. My name is David Jenkins. I am a resident of the city. First, I want to congratulate Commissioner Gonzalez on her appointment. I wanted to say that I want to thank you for your service as a commission on the city's most important planning body. I also appreciate hearing your advice and comment on development and planning matters. I think that's important for our council to know what the people dealing with it by our staff and yourselves. Secondly, I'd like to just say briefly that I want to give thanks to Mr. Thomas, Mr. Hitchcock, and Ms. Broccoli O'Malley for their help in guiding community members in our very complicated development review process. And in particular, I want to say thank you for caring and concern to place displaced and vulnerable residents of our city in affordable housing. It's truly a wonderful thing that they do to show heart in the busy work that they have to do. That's all. Thank you for letting me speak.
Thank you, Mr. Jenkins. Anyone else in the audience for public comment? How about by Zoom?
We'll go ahead and open up our Zoom platform for anyone who would like to provide general public comment. There are no hands raised, Vice Chair.
Okay, thank you. We are going to start with reorganization of the Planning Commission with the 2026 Chair and Vice Chair selections. So first, we'll open it up for public comment. Out in the audience, anybody? Nope. Anyone by Zoom?
No hands raised.
Okay,
Vice
thank
Chair.
you. Okay, so let's go ahead and open up a discussion about Chair and Vice Chair selection.
Well, myself, I'd like to place Julia Luxinger into the chairman's position. She's done an excellent job taking over from Natalia, and I think she'd be a great chairman, so I place her name in nomination.
Thank you.
I'll second that nomination.
Okay.
Would third it if I could.
Well, thanks. I am willing to do it. We need a vice chair suggestion.
So, you know, I think either Gavin or myself, both of us have both been vice chairs, 3 different years. Doesn't matter to me which one, either one.
Yeah, same. I think with, I think either of us would be a good one for sure too. Do you have an interest in doing it? I was vice chair a couple years ago, and then Julie took over for me.
And yeah, last time I was vice chair for, under, you know, our previous chair. So it doesn't really matter to me one way or the other.
I do concur with that decision, and I think you guys should go in the corner and fight it out. So go ahead. But anyway, no.
What, you can go ahead and do that.
Yeah, I'd be happy to. Yeah, thanks, Hug.
Okay, Mr. Feiger. So does anybody want to make a motion?
I'll nominate Mr. Feiger as vice chair.
I'll second that nomination.
Okay. Not letting me click on one?
We'll just do a verbal vote. Erica, how do you vote in this?
Yes.
And I will note for the record that Commissioner Gonzalez votes yes, so that motion carries.
Okay. Moving on to the consent agenda. Do we have any public comment on the consent agenda? So, yeah. So quick.
Oh, sorry.
Go.
And who is the?
We didn't even have to switch spots. Makes it easy. Okay, any public comment in the audience on the consent agenda? Nobody? How about by Zoom?
I do see we have one hand raised over Zoom. We have Lorraine Jackson.
Oh,
Okay. I'm going to allow her to speak and just see. Lorraine, did you have a public comment for the consent agenda? Which would be the
Hi,
approval of the...
I was just clarifying. I just wanted to let you know I'm here and I'm part of the agenda, but I'm assuming the consent agenda is something different than the appeals.
Yes,
Is that
this is for the
correct?
meeting
Okay.
minutes, so
Okay.
we'll make sure that you're
Okay.
given permission to
I'll let you
speak
know I'm
during that
here.
item.
Thank you. Thank you.
All right, and there are no other hands raised, Chair.
okay, thank you. So does anybody want to make a motion to approve the consent agenda?
I'll make a motion to approve the consent agenda and the minutes.
Okay,
I'll second.
okay.
And then Erica will take a verbal vote, so would you like to vote
Yes.
yes or no? Okay. And I will note for the record, Commissioner Gonzalez votes yes. And that motion carries.
Okay, we are going to move on to new business. And our first item is a vacation home rental application denial appeal for 2896 Springwood Drive. And I am going to recuse myself from this item due to a property that I own in the vicinity. So I'm going to pass it on to Gavin.
First item is chair.
Yeah.
Vice Chair, if, before we start the item, if you could read through the appeal section to just make sure everyone's on the same page with the protocol.
Yep, I will.
And if you don't have it in front of you, I have a copy here for you.
I do have a copy here.
Great.
Please correct me if I omit anything. So, yep, we will have an appeal. The general procedure is as is this. The chair explains that we're considering the appeal, which we've done with this item. And then we'll hear evidence and testimony in the following order. We'll have an opening statement or remarks by city staff to provide background information on the matter at issue. There aren't actually time limits on this, but suggesting about 5 minutes on this one. After that, there'll be an opening statement or remarks by the appellant and or the appellant's attorney, and any evidence or testimony from the appellant, aim for about 10 minutes on that one. And then us commissioners can ask questions of both staff and the appellant or the appellant's lawyer. And then staff will have a chance to basically do a rebuttal to respond to any issues raised by the appellant. And then the appellant and the commissioners will have a chance to ask city staff any clarifying questions. And then the appellant gets one last chance or their attorney to do a rebuttal or clarification of any of the evidence presented by the city. And then there will be a public comment period.
And Vice Chair, as mentioned earlier, due to technical difficulty for members of the public, there are copies of the PowerPoint available.
Thank you. And for commissioners, this one you do have in your on your electronic files here. So with that, we will start with remarks by staff to provide background.
Good afternoon, Vice Chair and members of the Planning Commission, and I'd like to congratulate Ms. Gonzalez on her appointment to the Planning Commission. Look forward to working with you. As Vice Chair mentioned, this is a VHR appeal of a denial of VHR application for 2896 Springwood Drive. The appellant is Ms. Lorraine Jackson. Her application was received on June 23rd, 2025. The property was officially buffered out on August 25th, 2025. Subsequently, Ms. Lorraine Jackson submitted an appeal on September 2nd, 2025 to the city clerk. That concludes my initial presentation, and I will present evidence that we have in the record to support the denial. Thank you.
Thank you, Mr. Hitchcock. Now we'll go to the opening statement or remarks by the appellant or appellant's attorney. I believe she is online or on our Zoom.
Yes, I do see we have Lorraine Jackson's hand raised, so Lorraine, you may speak.
Hi, thank you. My name's Dr. Lorraine Jackson. I appreciate this opportunity to speak today. I want to begin with context. I'm not a new or inexperienced operator. I held a vacation home rental permit in South Lake Tahoe from the time permits were first required, and for over 20 years I complied with every update and amendment to the ordinance. My permit history remained in good standing until Measure T interrupted the program. Over the years, I've invested a lot of time and resources to ensure my property complies with all the requirements, including fees, signage, inspection equipment, etc. My commitment to compliance demonstrates that this appeal arises from procedural inequities, not a failure to meet standards. The city's report emphasizes that another applicant submitted their application on June 23rd at 9:30 a.m., while I submitted mine the same day at 4:56 p.m. While that's accurate, those few hours is not what caused the different outcomes. The delay that materially affected my application occurred 28 days later on July 21st. The city requested additional documentation from me to confirm ownership. Based on discussions with city staff, I appeared in person with several city staff members, One of the factors contributing to the delay seems to be limited staffing, which was beyond my control. Without that delay, my application would have progressed on a comparable timeline, and in hindsight, it felt like being held at the start of the line of a race for 28 days while others proceeded. The city's chronology also highlights that I did not pass my first inspection while the other applicant passed inspection on August 7th. What that chronology does not fully explain is the nature of that difference. I was required to install a pan under the water heater that I had, which I did within 1 week using a permit and licensed contractor. I later learned that I actually didn't need to have the pan because it said technically that only if the water heater had been replaced, and mine was original. Nonetheless, I complied, I corrected the item, and I passed reinspection within a week, both pulling a permit and also using a licensed contractor. There were no ongoing violations. On that same date, August 25th, we both received letters from the city, the other applicant and myself. The other applicant received a letter stating their permit was issued. I received a letter stating my permit was not eligible due to the 150-foot buffer, despite having passed reinspection that same day. After my appeal was filed, the city conducted a site inspection of the other property that was creating the buffer on December 15th, 2025. That inspection confirmed that their exterior sign was visible but not legible from the adjacent right-of-way. The planning report that I have in front of me advises that the Community Services Division staff contact the permit holder at 2883 Springwood to request they have a new exterior sign. The ordinance requires that to pass inspection, vacation rentals have a clearly visible and legible exterior sign visible from the adjacent right-of-way. The city's own December 15th inspection confirms that this requirement was not met by the person issued the permit first. Had the other applicant been required to correct or replace or reorder their external signage before permit issuance, it's possible my permit would have been approved first. By contrast, I was required to correct even minor inspection items before approval. For example, interior signage, which had passed inspection previously, my inspector wanted it oriented a different way, which I complied with. The other applicant was allowed to correct the ordinance deficiencies after the approval of their permit issuance, which is highly irregular. This unequal application of enforcement is the core issue of this appeal. The city's failure to verify or require compliance at the time of the permit issuance was not my mistake, yet I'm the one bearing the consequences. To put simply, should a permit issued when the applicant was not in compliance with the ordinance be treated as valid for buffer zone purposes? It would seem that a permit issued without full compliance should not create a buffer that permanently precludes another compliant applicant. I would also like to briefly address the 150-foot buffer requirement. The Planning Commission report does contain a typo or error on page 2, item 9. It says it's clear the buffer encroaches on 2890 Springwood. Just to clarify, 2890 Springwood is my next door neighbor's house, and that's fully engulfed in the buffer. My house is 2896 Springwood, and from the diagram, my house itself is not in the buffer, but a minimal left corner of my lawn appears affected. Since my written appeal was filed, the City Council has drafted ordinances repealing the buffer. That effort failed, though, because of a tie vote caused by an incomplete council. Again, it's unfortunate that the occurrences happened and that the issue has been postponed because the city has not been able to seat a 5th member. This demonstrates that the buffer requirement is a little bit unsettled and under active reconsideration, it would seem, yet it is applied very rigidly in my case. I understand the city may be concerned that approving this appeal could set a precedent regarding the buffer. I respectfully submit that my case involves specific and unique circumstances. My application was delayed almost a month by a city request. The other applicant was issued a permit despite signage that was later deemed non-compliant. It seems the crux of the city's argument to deny the appeal is that it's on a first-come, first-served basis, but that really should only apply if all applicants are held to the same criteria. Not only was I held back at the start of the race, but the other applicant was declared the winner before truly crossing the finish line. I ask that you consider these facts and affirm this appeal based on the equities present in my application. Thank you.
Thank you very much, Ms. Jackson. Okay. Now we'll have a chance for any of the commissioners to ask questions of Ms. Jackson, and then we'll have staff ask any questions of Ms. Jackson. Any questions from the commissioners for the appellant?
Yeah, so I have a couple questions. First of all, I want to say that, Doctor, you stated your case very well. I kind of zeroed in not so much on the buffer zone, but because of, that's an issue that right now is with the city council, and it's by their failure to get this resolved is why we're having this difficulty. But one of the things that I would like to zero in on is the signage, because I believe you're correct, and I think this is more from the city that I need to ask this question of. The way I understand it, if the signage is not proper, then your permit may be delayed, or if the signage is not proper, then they may be excluded from getting their permit up to a certain extent. But I read here in the city where it said city staff shall conduct a site inspection on December 15, 2025, and confirm that the sign at 2883 Springwood has a black background and a white front. The sign is visible from the street, which they say that's fine. However, the font was not legible to the inspector. So my question is, if the font is not legible to inspector, how is it visible from the street? Also, they indicate that the staff has conducted or has requested the permit holder to put up a new exterior sign. So, Doctor, I ask you this question. If, for example, that, or do you feel because that the sign was improper that you might have been able to get your permit prior to this person, this individual?
Of course, we will never know how quickly they might have corrected that or how long they might have taken. To order a new sign can take 3 to 4 weeks at some places, or if you find a place that's quick, maybe they can do it in a week. But I guess the bottom line is, that their sign was not in compliance with the ordinance. If they're recommending the Community Service Division staff contact them in December, many months after the permit was issued, to put up a new exterior sign, and the ordinance under item J very clearly says it's not a suggestion, it's a requirement that the sign be both visible and legible. Being visible means maybe you can see a sign of some sort on someone's house. Being legible means that it's readable. And what the inspector, the city's inspector, found is that it's not legible. The font is not legible. My own experience of living on that street, I kept looking at the street to see if anybody had a sign up. Nobody had a sign up. I was only made aware that their sign was up by my second inspection, where I was told that he said that he had passed a house on the street. And then I went and asked him what house and went looking for it and could not see their sign from the street, and realized they did not place the sign closest to the street, which would be next to the driveway. It was placed under a patio in a dark entrance area, which their house has green paint and the sign was black. And so, it may seem like a technicality, but either you have met the criteria in the ordinance to get a permit or you haven't, and they hadn't. And that just adds to sort of my own, concern and frustration of spending over $5,000 to get my house in compliance, rushing as fast as I could, and, despite being held back with the request for my ownership. So you can see, I think some of the issues, and I appreciate your good question.
These are questions for the appellant. Our next step is questions. The city will present a lot of questions for them.
Yes. So, under your first inspection, was it just the hot water heater pan that stopped you from passing on to that first inspection?
There were a number of things that were corrected. Some were corrected that day, the day of the inspection. For instance, I had hired somebody to rake up pine needles, and all the pine needles were in bags. And the inspector I had, the intention was to put them out on the day that the pickup was. But the inspector wanted them all removed from the property. I complied with that. I hired someone to take them away. So there were a few items which I was dealing with right on the spot. I don't have that report right in front of me, but it is in the appeal. And there were several items that I corrected that day. The one that I couldn't correct that day was the pan. And, I did that within a week, both getting the permit and getting the new pan. And later, upon rereading, finally, with a fine-tooth comb, it says that those pans are only required if the water heater's been replaced. Mine was actually original. I must have had a very good one, but nonetheless, I replaced it. But to answer your question, there were a few items. My house had previously been a vacation rental. It had like interior signage still up from the previous past inspection, and she wanted the orientation of that signage changed, which I did. And there were a few other things that, that were taken care of, but essentially between the first inspection and the second, I complied with everything.
Okay, yeah, so, but there were some other items besides the
Yeah, yeah.
tan. Okay.
Yeah, there were some other items and like little things like, they tested all the GFI outlets. One of my GFIs wasn't right. I had a handyman with me within 15 minutes who lived around the corner. He came over and he corrected that, so I texted the inspector that day, and, she only required, for instance, of the pine needles pictures, but other things, she was there. He came so quick, he corrected that during the inspection. The other thing she wanted was I had my decibel reader, which I had purchased upstairs. It's sort of an A-frame with loft. She wanted that moved downstairs. I did that, so it was a big rush to try to do everything, but I got it all done and, put it first.
Okay. As far as the statement on the other tenant, we don't know how long they could have gotten their sign done. I know there's two local sign makers who have them made up within 24 hours. So we don't know if it would have gotten enough time for their permit to issue.
We don't know how fast somebody would do something. They passed inspection on August 7th. They didn't pay for their permit, it looks like, until August 21st. So sometimes people, take their time doing things. I can't predict when they would have gotten their sign corrected. All I know is that at the time they were issued a permit, their home was not in compliance.
Right. Okay, thank you.
Yeah.
Thank you, Ms. Jackson, for the responses so far. I think of one more commissioner question. I will note that the infractions, or she was just mentioning, are all in detail on your attachment number 3, and then the timeline, of course, is in detail in the staff report.
Yes, thank you.
Hi, I have 2 questions for you. The first is, you said in your opening statement that you realized that you didn't need to replace the entire heater, and you maybe didn't need to replace the pan because it was the original. Can you explain how the inspector told you what the issue was and why you made the decision to replace the whole heater?
Well, the inspector has a checklist, and on that item, she failed me. And my house had passed inspection without the pan previously, so it just, was a surprise to me. But to put a pan under a water heater, you have to lift the water heater, which means you have to drain the water heater. By the time you do all of that with an old water heater and put a fresh pan under it, you've disrupted all the pipes, and you've, now putting in an old water heater. And as a sort of responsible homeowner, even though my water heater wasn't broken, it made sense if she was requiring the pan to replace it. and the Nixons, the company that did it, you know, it was done very quickly. I was very grateful to get squeezed into their schedule, and they, you know, it was a $2,400 water heater. And so to answer your question, the reason I made the decision to do it is to not argue with the inspector, and to get it done as fast as possible, to comply, which would benefit the process. And I also, it was also later when I really, really read the fine tune, like the way that it was worded, it said that if the hot water heater has been replaced, it requires a pan. And, you know, mine was original to the house.
And sorry, that added an additional question for me. You said that your house passed the last inspection with the same heater. When was that? What year?
There were a few different times that, you know, I know that, for instance, in 2003, when you first had permits required, I complied with everything and got a permit. And then there was a major revamping in 2017 of some of the requirements. They required like a chimney inspection, which they did as well again this time. And I can't say with absolute certainty because I don't have documentation right in front of me, but my memory would be it's around 2017. And at that time, I was required to put straps on, which I hadn't been required to initially, and I complied with that. And so the water heater was strapped, and then the newest thing was, you know, the pan. So it had passed. The water heater has never leaked. It's in an exterior door on the side of my house, and so, you know, just evolving regulations, and I complied with all of them.
Great. Thank you for sharing that. And then my final question has to do with the trust. I didn't see, although, or maybe I just forgot, when your trust was created, yeah, I guess generally when the trust was created, that flagged the potential change of ownership.
Yeah, and you know, that was done a couple years ago. I'm a single parent, and I, you know, was concerned that with California's probate, if I passed away, my daughter would have to pay a lot of fees. So I basically consulted with an estate planner, and they said to do that. But the house didn't. You know, I'm the trustee. I'm the only person that's ever owned it. You know, I've been a professor for a long time, and back in the day, I had a choice of whether to invest in a home or invest in my 401k, and I put all of my efforts into my home with the dream of being able to enjoy Lake Tahoe, which I have always loved, with my daughter. And it's been a very emotional and difficult experience. I, you know, spent a great deal of time writing the appeal in my summer, and I have been very invested because, you know, I care about this home, and as evidence of my good stewardship of this home, in over 20 years, I've never had a complaint. And I realize the other person is similarly situated. They are in compliance with, I guess, a lot of things too, but you know, they were not in compliance with everything required of a permit. And I was held to a lot of standards. I met them all, and it is just extremely difficult to feel held back at the start of the race, and to feel someone was declared a winner before they finished completing everything that was required of all of us. So that's a little bit of background.
Thank you, Ms. Jackson. Recognize you're not here in the room. Recognize that this is very emotional, and these appeals definitely are. So thanks for your time so far. Any questions of the appellant of Ms. Jackson from city staff? Okay, we'll move on to the next step, which is city again, evidence or testimony concerning any new issues raised, as well as just any evidence you'd like to provide, Mr. Hitchcock.
Thank you, Mr. Vice Chair. For the record, John Hitchcock. Ms. Jackson actually did a very good job of going through the chronology. She got her property was buffered out by 2883 Springwood Drive, who, beat her to getting a permit issued. The delay in her application had to do with the ownership. In her previous VHR permits, it was under her name. As she mentioned, she transferred it to a living trust. So when the application, I believe it's a living trust, when the application was submitted, there was a discrepancy between the original permit that was issued by the city and the new application. So the names didn't match up. That resulted in the Community Service Division asking for additional information to verify ownership, which occurred, let's see here, ownership documentation was provided on August 6th. Subsequently, however, on August 7th, the other property passed inspection and paid the permit fees August 21st and was issued a permit on August 25th. Mrs. Jackson property completed inspection on August 18th. And so that's the chronology. I understand her concern that, that delay really put a monkey wrench into her application process. And that concludes my presentation.
Thank you, Mr. Hitchcock. And now is a chance for commissioners first and then the appellant to ask questions of city staff. So any questions from commissioners?
In all reality, this is pretty technical because we're talking about giving one person a permit on one day and sending out somebody saying we're denying you the other. And so I look at it and I kind of say we're in very technical grounds, and I look at the signage issue. And for me, that's difficult to allow one person to get a permit without proper signage or something, proper signage. Thus, I ask you the question, is that, in your opinion, a matter that should be discussed or whatever? Because when we get so technical in this particular case, it's kind of like, sometimes it's just like tie goes to the runner, so we may want to go with the appellant, So this is really difficult for me because of the sign issue, regardless of other things that have been brought up.
Yeah, understood, Commissioner. So the sign issue, I can't read the mind of the inspector who approved the checklist, which then resulted in the permit being issued. As a result of Ms. Jackson's appeal, I was the one that actually went out and looked at the sign to verify whether it was legible. As she mentioned, it's a dark background, and I actually think the letters I don't think it was white, I think it was actually green, so it was not readable from the street. At that point was when I informed the Community Services Division, who then went out and I believe did a subsequent inspection and directed that property owner to update their signage. I can't speak of what procedural what would require the city to revoke the permit. That's really would be a question for probably legal counsel. But there's no provision in the code that talks to that. But you're right. The code is very clear that if you have to meet all the requirements of the code and get past your checklist in order to get a permit.
Yeah, because it said here, not legible to the inspector. So, I get it. My question is that we're in a buffer zone area, but if we granted her appeal, the buffer zone has nothing whatsoever to do with us granting her appeal, and there is no repercussions on the other permit holder, correct?
Mr. Barzell, did you want to?
We do have, we have a precedent for this at this point. There was an earlier appeal where this came up, and the commission did decide to grant an appeal despite the fact that there was a buffer that would have prohibited it based on the city code language. And I believe in that instance, the commission did decide to grant an appeal, and it was up to city staff to decide if and when they wanted to consider revoking the other permit in the future.
Okay.
But the city code is clear 150 feet.
Yeah, I get it. Yep. Thank you.
Thank you.
That's all I have.
Just to follow up on the signage, the sign says legible, but it has no, or the code says legible. Is there anywhere guidance internally that explains legible for who? Because I think there's different, I think it's a fair assessment to say that for some people, some people do not have perfect 20/20 vision, some people struggle with color blindness. Do you have a definition? Does the internal administration have a definition for what legibility means?
There is not. There's, the code is silent on what legible means, and there's no standard that says that, the letters have to be a certain size or anything like that. So it's possible that that signage could be legible to someone. To me, it wasn't. I mean, I have bad eyesight, but.
And to clarify, the inspector found it legible, though.
Yes.
So I think that's interesting. The other question I have is related to the trust. I know that the application was sent back related to the trust. Is that because on the back end for you all, it was hard to confirm ownership because of the switch in the trust?
That's correct. So when individuals put their name into a trust and it shows up on the assessor's parcel data, it lists the trust. It doesn't show who actually owns the trust itself. And so it was the responsibility of the Community Services Division to verify that Ms. Jackson's name was still, her name and only her was listed as the owner of the trust. And they do that because if you transfer property into a trust, into a different name and different owner, that makes your property ineligible for a short-term rental permit.
Okay, great. And then just another question. On the PowerPoint, it shows the visual of the 150-foot barrier, and it does look pretty small on the image, but I wanted to know if you could provide exactly how many feet within the perimeter it is?
I don't have the actual footage, the length, but I did talk to Ryan Maholsky, our GIS director, on how the buffers are created. So this Community Service Division actually has a tool that they use in GIS that they put in the property line, and then the system will then draw a buffer, and then will select every parcel that is touched by that particular buffer. So it's pretty accurate how we go about doing this.
And then just another question. This one is interesting because how small the buffer is, but are there other instances, are you concerned that if we approved something like this, that there would be other, I know it's hard to predict, other parcels that could be impacted by this like small encroachment into the 150?
I think it's going to be pretty common. You're also going to find, if you look at the VHR map, which I took a look at this morning, there are instances where you're looking at buffers, and you would think that the buffer would buffer out another property, but when you go down to a very granular scale, it doesn't. That's why we rely on the GIS system to draw the buffer map and then return all the parcels that are affected by it or where a property line touches that buffer zone.
Great. And then my last question is, the initial applications were filed the same day, but there is an hour time, like a couple hours of time difference. In that case, had everything been approved and gone through, fine without these issues of having to resend the application back, of failing the first inspection, would the process have been that the other property would have still been permitted first because of those hour differences?
That's hard to predict, and it comes down, if both properties were deemed complete on, let's see here, July 21st, then it comes down it's hard to predict because then it's up, once it's deemed complete, the CSO will actually send an email to the property owners saying, please schedule your inspection. Then at that point, it's up to the property owners, how fast or how slow they want to get an inspection completed. And then it comes down to whether your property meets the building code standards at the time that property was built.
Oh, and that reminds me, sorry, I'm sorry, it's my first meeting, I'm already asking a lot of questions. When have inspection checklists, when was the last time they were changed or updated?
I don't believe it has been changed. Are you aware of it being changed, Mr. Thomas?
So the last time it was updated was when the newest, when the ordinance was adopted by the city council this summer. The things that were added was I think that just the defensible space requirement and the noise monitor. I just had the checklist pulled up. But regarding, for instance, like the water heater, that wasn't changed. So there was minor modifications made to the checklist at the time of the new ordinance being adopted.
Okay, thank you.
How sure are we that these maps are accurate as far as property lines?
According to Ryan, they're very accurate. And I actually, for this particular property, just out of my own interest, because the encroachment is so small, I pulled the subdivision map and manually tried using that map to manually kind of calc that buffer, and it did encroach based on the adopted subdivision map.
Based off the subdivision maps?
Correct.
Okay.
Just for the record, I just want to clarify, because what Ms. Gonzalez said, and then your response was the font legible to the inspector?
Well, the inspector approved it, so I would assume yes.
Because right here, under item number 4 on the issues and discussion, it says, however, the font was not legible to the inspector.
That's
what it says.
Is that in my staff report, or?
That's in this one right here, though.
I believe the clarification was that it was legible to the inspector,
Well, that's
but
what
it
says.
wasn't.
Not legible, the font was not legible to the inspector.
Mr. Hitchcock,
One sec here as we-
yeah, item number 4 says, city staff conducted an inspection on December 15th, 2025, and confirmed that it was not legible. In that case,
That was me.
That was Mr. Hitchcock.
Yeah,
It was two different, so there was the initial inspection in the
initial
summer.
inspector, and okay.
And
very
then
good.
on December 15th,
Gotcha.
Mr.
Sorry.
Hitchcock.
Yeah.
But, yeah.
And I went out because of Ms. Jackson's appeal, where she said it was legible. So I wanted to confirm
Right.
that that was the case, and I went out and did an inspection.
Got it. Thank you for that clarification.
Any other questions for staff from commissioners? Okay, then we'll move
Thank
I think 1 second here. Sorry, Mr. Hitchcock. Ms. Jackson, if you're still there, this is a chance to ask any questions of the city. Sorry.
Sure. Do I need to raise my hand or anything? I just wasn't sure if the recording was on. Can you
no,
hear
we
me?
can-
That's okay, you
We
can
can hear
speak,
you.
Lorraine.
Okay. I guess I wanted to thank John for going out and verifying what I had stated in my appeal, that it was not legible. We can only speculate why it was passed when it was not meeting that requirement, but I did have 2 different inspectors. One was very, very strict, and one was very, very lenient. And the second one, who was more lenient, was the one who approved that sign. He may have stood on their doorstep, looked at the sign and said, okay, it's there, check. Not really reading the full ordinance, which item J is pretty specific about, that it be visible and legible from the adjacent right-of-way. And so, I mean, we can only speculate on why that was not flagged and corrected. But I want to mention that, the training of consistency among inspectors is something that falls under the purview of the city. And it is, there are real consequences for people should that training not be consistent. And I observed inconsistencies between the two inspectors I had, and I suffered because of them. And I think that is something that, I don't have time to get into everything in my little 5-minute statement, but I honestly believe if I had had that first inspector, that second inspector, it would have been a different outcome. And that shouldn't be the case. I mean, it should be the case that the city is training these people, they're using the checklist appropriately, nobody is advantaged over someone else. I mean, one of the critical things I want you to really talk about and consider is it fair to let someone correct things like their sign after they've been issued a permit, and yet hold another person strictly to a timeline that they have to adhere to before the permit is issued? And that is an issue of justice. And the whole appeal process is designed to look at these things a little more carefully. And I understand that, you may be reluctant, with the little encroachment of the buffer to set any kind of precedent, but I really do believe my case is not really just solely based on that small encroachment with the buffer. I think it's really dealing with a very important procedural matter, and a procedural matter that has consequences. And I would say that I'm not asking for preferential treatment. I'm only asking that the ordinance be applied consistently, and that a premature issuance not be used to deny a compliant application. And that is really the crux of this appeal, and it's something that I feel really deserves your recent time, and not to just rubber stamp a deny, but to really think about that and put yourself in my position of knowing someone else got a permit without being in compliance, and knowing you're being denied and being held to a standard that the other person wasn't held to.
Ms. Jackson, we are going to move to our last piece here, which is, I think you're off the hook, Mr. Hitchcock, thank you.
Yeah, nothing for me.
Nope, it doesn't sound like it. So I think we're at the last step here, Ms. Jackson, where just anything else you have left, any rebuttal or clarifications or any final remarks you'd like to make beyond the statement you just made.
Just that I appreciate you all giving your time and attention to this. I know that it's a technical case, and I've tried my best to outline some of the various reasons why I think you should affirm this appeal. I know you have another appeal to hear, and I don't want to hold you up with anything further, so I just want to say thank you. I know this is not easy, and I know there's been issues affecting the city council, and they've affected all of us, and I hope the city can proceed and make some intelligent decisions about this buffer that's caused so many problems.
Okay, thank you very much. We will move on to public comment then. Any public comment in the room on this item?
We'll go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 3. There are no hands raised, Vice Chair.
Already did the room, yep, I think we're good. So now we're back to our commission here. So we, as a reminder, deliberate on the evidence and testimony presented, and vote whether or not to grant an appeal or deny the appeal. If we don't feel like we have all the necessary information, we can talk, or if there are issues that we can't resolve for some other reason, then we can postpone this hearing. So anybody want to start the discussion here?
To me, the sign thing, it could have been taken care of in a day. She was approved. The one at 2883 Springwood was approved a week to 10 days prior to the inspection on the applicant. That sign, I know, like signs of Tahoe can get a turnaround on a day of fixing that sign. So I can't say that she would have if they would have said no on 2883 Springwood, that they could not have had their inspection done and approved, still a week ahead of hers. It's completely possible that could have been happened. My only question otherwise would have been, I hate the buffering. I don't like it. I've never liked it. I told city council members when they were voting on it that it's an issue. But it is what it is, and we have to abide by what the city code is at this time until it gets changed.
Two words come to me: technical and fairness. And that's about it. So I'm ready to move on this.
I definitely appreciate the emotional component of this. I think when I first looked at this, at the evidence in the agenda packet, I was like, the small encroachment, this feels unfair. But in looking at the order and the chronology, it wasn't just the sign. And the sign is a hard one because legibility is subjective. And I think that if the city wants to standardize some component of it, there are methods of doing that they could look into for administrative. ADA compliance for signage for electronic stuff is a thing. But that being said, at the end of the day, legibility is subjective. And I think the fact that it only says legible, and the question is legible to who? It could have not been legible to Mr. Hitchcock and legible to me. But to me, that's not the turning issue here. The turning issue is the order of operations in which everything happened. And I do think that Ms. Jackson did everything she was supposed to do according to what was offered, but it's the trust issue. The trust issue had to, as a homeowner, I imagine that there is some kind of information that you have in anticipation that ownership is going to be looked at in a case like this. So between the trust issue, the first failed inspection, and if everything had gone according to plan on both, that maybe 2883 still got approved first, we'd still be in this situation. And this one was a really hard one for me to look at, and looking at the encroachment and the small sign. And I want to acknowledge that Ms. Jackson has been a good permit holder. But I think based on the ordinance we have, this one, as I look at it more, is a little bit more clear to me in terms of order of operations.
Yeah, thank you, fellow commissioners. A couple thoughts on my part. The ownership part is difficult, but I actually, unfortunately for Ms. Jackson, appreciate the city looking at it closely, because we had that issue in El Tahoe where somebody got a permit and even though they didn't have ownership in time, and we talked about that one for a long time and actually granted that appeal. So the city is very well warranted into looking at that in detail. And then, the other parts, it is a small buffer, the signage. I would recommend we have an agenda item at the end of our meeting today to transmit more, I'd send more feedback to city council. And I think signage guidelines, especially something around ADA and font size, I was hearing, is something we should definitely recommend for signage to get this ambiguity out of there. As well as the inspector training and consistency. I don't know what kind of direction we give for that, but maybe just kind of highlight it as something we've heard. So those are my thoughts. I think based on the current ordinance with the buffer rule, our hands really are tied. But
They're not. I don't think so.
so I'll leave it up to anybody. Any further discussion here or a motion?
I agree with her. Our hands are not tied. I think you've got to consider the fairness issue. I think you've got to consider the signage issue, and I think you've got to consider this whole case. It's a travesty. Thank you.
Mr. Imhoff, can you clarify what your concerns are, particularly with the signage, though? I mean, to say that this is, yes, I think it's not as clear as we would like it to be, but I think to the inspector who inspected at the time, they found it legible. And we have to go on the faith of the inspector that they know how to do their job and that they are trained. And if there is more clarity in the training that we need to issue to the city, then that's one thing. But that inspector at the time who we've assigned to do these in their expertise found it legible.
I believe there's enough ambiguities, or whatever you call it, in this particular case that it's just not right. I mean, you've got a case where two applications, one's being approved, one's being denied, and we've got sign issue, so on and so forth. What purpose is this committee without, actually, having some feelings towards this? I mean, otherwise, there's no reason to show up.
Okay, so I'm going to want to make a motion, as much as I hate having to make this motion, because I really do hate the buffering zone, that the staff is recommending that the Planning Commission deny the appeal for the following reasons. Mrs. Jackson's property at 2896 Springwood is not eligible for the VHR permit pursuant to SLTCC Section 3.5.380 F1, which prohibits the operation of a VHR that is located within 150 feet of another parcel with a valid VHR permit.
I'll second that.
Because Commissioner Gonzalez isn't in the system yet, but she did second it, so we'll just do a verbal vote. We'll start with Vice Chair Feiger,
Yes.
Commissioner Imhoff,
No.
Commissioner Williams,
Yes.
Commissioner Gonzalez.
Yes.
And I will note for the record that Chair Lexinger has recused on this item, and that motion carries.
All right, thank you, everybody. Yeah, let's take, does anybody need a quick break to use the restroom or get a drink or anything, or should we just keep going? He went to get Julia. Oh. Yeah, so does anybody want to take a quick break, or everybody okay? Okay. Welcome back, and our chair will take it over and carry on.
So it looks like we are going to move on to item number 4 on the agenda. Vacation home rental application denial appeal, 2480 Conestoga Street, Unit A. And we'll go through the same appeal process as before. Just to recap, we'll hear testimony in the following order. Opening statement or remarks by staff, for background information, and then an opening statement or remarks by the appellant or the appellant's attorney, and evidence or testimony from the appellant, followed by any questions by the commissioners or others, including staff who wish to ask questions. Then we'll move on to any evidence or testimony from staff members concerning any issues raised surrounding this matter, followed by comments by the applicant if the applicant and appellant are different parties, followed by any questions by the appellant and commissioners. Then any evidence or testimony from the appellant or attorney in rebuttal or in clarification of any evidence or testimony presented, and then any closing statements or remarks that they wish to make. And then lastly, we'll end with public comment before discussion and a vote. So with that, Ms. Schoolman, we will start with you.
Great.
Thanks.
Good afternoon, Madam Chair and Commission members. For the record, my name is Gretchen Schoolman, and I'm an assistant planner with the City of South Lake Tahoe. The item before you is an appeal for a vacation home rental permit denial for the property located at 2480 Conestoga Street, Unit A. The appellant is Mr. Duggan Smith, and the VHR application was submitted on November 30th, 2025, and was deemed ineligible for a VHR permit on December 3rd, 2025. This was due to city staff finding that this was a multifamily dwelling unit. City Code Section 3.50.380D1 states it is unlawful to rent, lease, use, or operate a multifamily dwelling unit as a vacation home rental. On December 11th, 2025, Mr. Smith filed an appeal with the city clerk. That concludes my introductory remarks, and I will provide further evidence in the next portion of the appeal. Thank you.
Thank you, Ms. Schoolman. We will move on to Mr. Smith. And you can provide any evidence or testimony up to about 10 minutes.
Sure.
Thanks.
Don't think I need that long. Hopefully this one's a little simpler than your last. Good afternoon, everyone, commissioners and staff. Thanks for hearing me out today. I'm here to appeal the decision to deny my application at 2480 Conestoga Street, Unit A. My name is Duggan Smith. My wife always tells me not to start this way, but I came in here in 1998 as a J1 worker at Heavenly from Australia, and I've kind of built a life here the old-fashioned way from the ground up. We were married in 2005. Our children are now 11 and 13 and in the local school system. We are local as local gets, in my mind, or our kids are at least, apart from babies. So back to this property. My wife and I bought this as our first home back in 2005. We lived there for several years, and then since then we've rented it in different capacities as a long-term rental and also as a short-term rental. We got vacation rental permits on both sides of this duplex around 2012. I'm not sure exactly when. 2015-16, somewhere around then, the City Council decided to stop issuing new permits on multifamily properties, but they did grandfather, I'm not supposed to say grandfather, they did prioritise old existing permit holders and allowed us to keep renewing. So we had those two permits in place all the way through 2021 when Measure T caused them not to be renewed. And as we know now, that shouldn't have happened. Measure T was unconstitutional, so we should have been able to continue renewing and renting those properties all along. Back to when we bought that building, that home, our first home, we decided we wanted a duplex because that was something that we could afford and use the other income to offset our expenses up here. And we were looking around for a while, and we decided on that one because it's on a great street. It's kind of part of the bike path through town. That's how we first saw it. And then the other great feature about that property is there's no shared walls between the units. The units are separated by a 6-foot wide utility space. So, we lived in apartment situations before and had issues with noise transference and whatnot. And that was a really appealing factor with this property, was that we wouldn't have to share a wall with whoever was next door to us. From there, this really comes down to definitions. So, out of the code, I did forget to say, did everyone get the email that I sent to staff and you're able to view that right now? Yeah, okay, great. A dwelling unit, from the definition here, quoting, a dwelling unit shall mean a building or a portion thereof that contains living facilities, including provisions for sleeping, eating, cooking, and sanitation for the exclusive use of one or more people maintaining a household. This utility space that separates the units is not part of either dwelling unit. It's separate, it's got access to the owner, it's got locked off from the tenants. It is not part of either dwelling. And then moving on, a multifamily dwelling unit is defined in the ordinance as, it shall mean a dwelling unit that is attached. And it goes further than saying attached. It says attached, comma, meaning that it shares at least one wall, floor, or ceiling with at least one other dwelling unit. So if we go through that piecewise, there is no shared wall. To me, a shared wall is when I'm on one side of the wall and someone else is on the other side of the wall. And that doesn't exist in this property. There's no part of the wall in the first dwelling unit that's within 6 feet of a part of the wall in the other dwelling unit. That's part of the reason we bought the house, and it's just not a shared wall. The floor and the ceiling, you can never really share a floor or a ceiling, otherwise someone else is inside your house. So I assume it kind of meant a floor and a ceiling being the same thing. Someone's ceiling is someone else's floor. But regardless, there's no part of the floor in this dwelling unit that is within 6 feet of any part of the floor or ceiling in the other dwelling unit. Furthermore, the floor structures themselves are totally separate in this building. So the utility space in between is on a solid concrete slab, and then the dwelling units on either side are on crawl spaces. You can see that in the city's picture. You can see vents down the side where the city has the street view of the property, so there's crawl space fence down the side. And I tried to show with the pictures that I sent you that the crawl space is level with the patio concrete, and it's a concrete floor as you go in there. And then the dwelling unit door is a step up onto the wooden floor that has a crawl space beneath it. So the floor has nothing to do with, there's no continuous floor through there. And then the ceiling, there's no part of the ceiling in the first dwelling unit that's within 6 feet of the ceiling of the other dwelling unit. The structure isn't continuous through either dwelling unit, through the utility space, or into the other side. So to me, it just doesn't meet the requirement. It kind of seems like the definition of multifamily was written really with the intent of stopping any disturbance between units, which I have issue with because I don't think a vacation rental is any more disruptive than a regular tenant, and in most cases less disruptive because we have our noise monitoring and our other rules in place that you can't affect that kind of control over a regular tenant. But regardless, these dwellings do have great separation for noise and disturbance, and we've never had an issue between us living next to other people, between having long-term tenants next to short-term tenants and short-term tenants next to short-term tenants. We've never had any complaint of any disturbance between the two units. I think I can finish there for now. If you've got any questions.
Thank you, Mr. Smith.
Sure.
Okay, we'll go to any questions from commissioners or staff to Mr. Smith.
This would be to the staff. When they did this new code, because the old one allowed the people to continue on with their VHR permit if they had multifamily housing units previous. When we did that, did they specifically say, no, you can't have it on a multifamily this last summer?
So I don't have the information in front of me that when that update was made. However, that is in the current code.
Right, but I mean, when the update last summer was made, because if we're acting like, okay, Measure T, the lawsuit came, and were you part of that lawsuit?
I was.
Yeah, that's what I thought. I thought you were one of the named proponents of that lawsuit. It's acting like it never was. It was found invalid. The people who had their permits before can apply for their permits. So it would. My reasoning would be that if someone had a multifamily unit, then they should be allowed to do it because they had a permit before, and the only reason they lost their permit was because of the Measure T.
So as laid out in the legal opinion that we provided to the commission, Measure T invalidated the QVHR provision, and the council passed a whole new legal framework for VHRs in the city. So the existing framework and the invalidity of a portion of Measure T previously are not connected. So the existing legal framework is what is at issue here.
I'm not quite following what you're saying.
So what I'm trying to say is that the fact that someone had a permit previously and Measure T was struck down, the new legal framework is what's at issue. So the invalidity of Measure T does not impact the current legal framework, which prohibits multifamily.
Because they voted on the new law in the last summer? Is that
Because
what you're...
the court decision in invalidating the QVHR provision, the city council passed a whole new, city code section about this, and that is not invalidated by anything to do with Measure T. So basically, the only issue that was found unconstitutional is removed, and a new framework has been put into place.
And to clarify, in the new ordinance, they did contemplate previously permits, right? Like the application period, that was included in the ordinance, correct? So where they wanted to consider back, it was included in the updated ordinance.
Yes, so basically, there was a preference application period that said that anyone that had a new ordinance could apply under the current rules. So basically, it didn't necessarily guarantee the issuance of a permit. It allowed them to apply under the current rules. And as the Assistant City Attorney is saying, the current rules with regard to this, as stated in the staff report, the multifamily dwelling prohibition is kind of what is kind of basically being discussed here. So the one provision that was adopted in the current ordinance allowed for a preferred application period, but not a preferred necessarily issuance or guaranteed issuance. It was an application period.
Okay, are there any other questions from commissioners specifically for Mr. Smith? And then we're going to move on to testimony from staff members about any issues raised, and then we can ask staff questions.
Yes, I have questions.
For Mr. Smith?
Yes.
Okay, great.
You got your permit from what you say about 2012, is that correct?
Yeah, somewhere around there.
Okay. And after the city changed their position on multifamily units in 2015, they allowed you to maintain your permit.
Correct.
Until the implementation of Proposition.
Correct.
Measure T.
Yes.
It's kind of like you were grandfathered in, right?
Yes.
Wouldn't you say that?
That is what I would have said, yes.
So I got a little struggle here, you know? If that's being the case, it's difficult to rule against you knowing that I cannot use an unconstitutional law in an appeal.
In that case,
law.
I'd like to apply
That's
to
law.
the other unit also.
That's law. And I'd like to go to council here, and we all take our oath. Ms. Gonzalez just took it today. To do what? To defend the Constitution and to defend the state Constitution. So doesn't it seem like if I can't use this law against him, then I just don't know where I would be on that. So you had made a mention that there are two different things, but I don't see where there are two different things when I can't use an unconstitutional law against him.
I mean, I'd be happy to discuss it in the discussion portion of it, but,
Well, no, I mean, you made a mention, counsel, that, you've changed the law there, you've changed the ordinance, that the new ordinance is going to come into play for him.
That's correct. So
But yet, the law says that we cannot use an unconstitutional law in an appeal. So can I go towards the Constitution instead of this new ordinance?
Commissioner, as I've explained, Measure T was found unconstitutional. After Measure T, after that occurred, we received that decision. The City Council passed a new framework for approaching short-term rentals,
I
including
understand.
this rule. So Measure T is not at issue, and it's no longer the law of the land for South Lake Tahoe.
Questionable.
Any other questions for Mr. Smith?
who is currently living in your other unit?
There's a local couple, a young couple.
So a long-term couple? Okay. And sorry, what their current lease term, is it year, or are they month to month?
Month to month.
Okay.
Okay, no other questions? Okay, so we will move on to evidence or testimony from staff members about any issues raised surrounding this matter. Ms. Schoolman's going to come up. And then we can, we'll take comments from Mr. Smith after Ms. Schoolman, and then we can follow up with questions. Thanks.
Thank you, Madam Chair. For the record, Gretchen Schoolman. When the VHR department received this application, they did reach out to the Development Services Division to see if this property met the definition of a multifamily unit as outlined in City Code. That code section is 3.50.370. I know we've kind of been over it, but by this definition, the multifamily dwelling unit shall mean a dwelling unit that is attached, meaning that it shares at least one wall, floor, or ceiling with at least one other dwelling unit. The property at 2480 Conestoga Street shares a continuous wall along the front and rear of the units, therefore meeting the definition of a multifamily dwelling unit as outlined in this code section. City staff reviewed street imagery as well as the building fact sheet to make this determination. We were also under the impression that the shared common space was accessed by both units. For this reason, you can also reference attachment 5 and 6, and it shows that street imagery and the building record fact sheet. Based on this, we made the assumption that it was an attached unit. And as you can see in that street view, it's a continuous wall. It doesn't have any breakage. The roof itself attaches the two units, but based on the current definition, we were focusing on the wall. And then a point that was brought up regarding previous multifamily dwellings that had a permit. In city code, it does mention that owners of a multifamily dwelling unit that are condominiums and had a valid vacation home rental permit at such condominium on September 1st, 2016 may apply for a vacation home rental permit. It is my understanding that this is not condominiums, it's one APN for the parcel. So unfortunately, that code section would not apply in this case. Staff is recommending that the Planning Commission deny the VHR appeal based on the reasoning presented, that the property located at 2480 Conestoga Street, Unit 8, meets the definition of a multifamily dwelling unit, and therefore is not eligible for a VHR permit pursuant to City Code. That concludes my presentation. Thank you.
Okay, thank you. Let's see, we'll go on to if Mr. Smith has any other comments based on Ms. Goldman's testimony that she just provided, then we'll move on to more questions.
Sure, just thank you. Based on that, you're really looking at what the definition of a shared wall is. And there's no definition in the ordinance, so that's your discretion to find out what you think that means in this case. There's a continuous wall that goes along the edge of the structure. No part of that wall is simultaneously part of both dwelling units. There's no section where there's one person on one side of the wall, one person on the other side of the wall. During this, I spoke to Mr. Hitchcock, and his sticking point was the roof, and that it's under one roofing envelope, therefore it's attached, and that's not in the ordinance. And it seems like the city has gone back and had a look at this and decided that, well, the roof isn't in the ordinance. That's not a thing. So we're going to look at this continuous wall, and because it goes from one dwelling unit to the utility space to the second dwelling unit, that's shared. And I don't. If I was describing a shared wall, that's not what I would describe. So if you had a row of condos, condo 1, condo 2, condo 3, and there's a wall across here, I would not say that condo 3 shares a wall with condo 1. I would say condo 1 shares a wall with condo 2, and condo 2 shares a wall with condo 3. Now, to me, if you wanted it to mean a continuous wall along the front, you would say that in the ordinance. You would say they're connected by a structural element. You wouldn't say, do they share a wall? So that's where I'm coming from with this. And then if you want to look at the intent, it really seems like it's noise transference. And that continuous wall isn't going to transfer any noise across the utility space and into the other dwelling unit. The neighboring property is 10 feet away and has windows facing directly to the windows of my dwelling unit. There's far more chance of a disturbance from particularly open windows across that 10-foot void than there is between this 6-foot enclosed space that's structurally separated. I've got a permit on another house that there's a fence attached to my house, attached to my neighbour's house. So we've got a shared wall connecting two separate properties on two separate parcels. So I just disagree with the city's interpretation of what a shared wall is. I think, they've kind of let everything else go on this, and I think really that's what it's boiling down to. If a continuous wall along the front is an issue, is it possible for me to break that continuity and to step the wall in on my utility space so it's no longer a continuous wall? I mean, that would have no benefit to anyone other than to meet the definition, but it would be something I'd be willing to do to meet the definition. I will have the opportunity to speak again, is that correct?
Yes.
Yes, okay.
Yeah.
Thank you, that's all for now.
Thank you. Okay, so if you don't mind staying up for just, if we have any questions, no problem. I have just a two-part question.
Sure.
The utility space, is it laundry? Is it for shovels and rakes? What is it?
It's been different things at different times. There are laundry hookups in there and storage at the moment. So yeah, at the moment there's laundry.
And it's not used by either A or B units?
No,
It's just
the
for
doors are locked
owner
off, yeah.
use? Okay. So with that question to Mr. Hitchcock, are there any minor modifications that Mr. Smith could possibly make to meet the requirement of?
The answer to that is yes. You could modify the house and so that it doesn't meet the definition of an attached unit. So he could modify that wall or create an alleyway. Mr. Smith was correct. We talked about the roof. We had internal discussion that that's not part of the definition, that doesn't apply. So as long as that is either a pathway or an alleyway, however you want to do it in there, then it would be considered detached units, then would qualify for a short-term permit. Now that said, that modification would have to happen before the city would be able to accept an application and issue a permit, because we don't have a mechanism to issue a short-term conditional permit with condition that says Mr. Smith needs to go modify the building to bring it in compliance, to bring it into consistency with the definition in the city code.
Okay. And would the space have to be like permanently open on each end to create like a permanent breezeway, or could he have doors on both sides to prevent like snow from blowing in, or what would that, or is that more detailed for the planning department?
It's more detailed, and I think that's something I would have to probably talk with the building official. If Mr. Smith just notched it in, and it's not this long continuous wall, whether that would be considered a detached unit, but I would also defer to Mr. Thomas. Do you have any opinion on that?
Yeah, I would concur. I would, regarding specific design elements, what we're looking at here is simply just the definition within the VHR ordinance, in the city ordinance, and it's just the concept of a shared wall. And what is kind of demonstrated both in visually and on the residential building record fact sheet. And so we'd have to kind of work with the applicant and, basically the building code, which is a totally different set of rules, to kind of get to a design situation where, it wasn't defined as multifamily. And so we wouldn't want to, kind of offer design elements at this point. But I think what you're hearing Mr. Hitchcock say is that in the kind of early discussions with this, with the appellant, that there is potentially, a redesign, remodification of the structure that could get there. But again, that level of detail just hasn't been done in terms of compliance with this, as well as building code requirements and, anything like that, so.
Okay. Any other questions from
Have
commission?
you had a discussion with anybody about making any design changes on your building?
I have not. I would be very resistant to that because of the last case you heard. If I, spend months and thousands to dogleg a wall and then someone else buffers me out, or the city changes the code in the meantime, that is, that's not a good outcome for me. And like I said before, doing that is not going to change the situation for any party involved with any of this. It would just be to meet a definition, which to me, the definition of a shared wall is fairly clear anyway, and I think I'm on the right side of that, and that's up to you to decide. Yeah, like I could be prepared to do that stuff, but again, just with the buffering and with the whole ordinance being up in the air anyway, and with it reducing the utility of my property overall and being a huge expense, it would be a difficult decision for me to make. I mean, if I could drywall off the doors easily and have that just be a void that's inaccessible, that is an easier fix if that meant anything. That could be done relatively quickly.
Is there an entrance outside of that breezeway?
There's doors on either side from the exterior and from either unit into the. So, I could block off the interior access to it and maintain an exterior one. Again, I'd rather not do that because that would be a good utility space if we're able to vacation rent for supplies and whatnot in that area, and just utility for me to keep whatever in there. But again, it boils down to what's a shared wall and what. I'm really confused why the city's so interested in not approving this. I really don't understand why, when I applied originally, they didn't reach out to me and ask what it was, and I don't understand now that I'm here and telling them what it is, why they are still, bending over backwards to look at the roof, and the roof doesn't work, so let's look at the floor doesn't work, so let's look at the wall. Yeah, it's not really shared, but it is continuous. They're looking for reasons not to give this to me, which I don't understand. I mean, I had this permit on it, it was in good standing, never had a complaint. I'm doing better, my tenants are doing better, and the city's doing better. And it's a small opportunity to do a little bit of justice on Measure T, even if it's not all the way right now. And I don't understand why the city hasn't been cooperative with me from the get-go. I'm disappointed that I got to spend money and time and waste your time here talking about what a shared wall is rather than being able to discuss that cooperatively with the city and come to something that's beneficial for everyone. There's no losers in this case. If anyone knows who's losing in this case, let me know and I'll address it.
Any other questions for Mr. Smith before we move on to public comment and discussion?
I have a question for city. Is that still this time?
Yep.
Okay. I am curious a little about intent. You brought it up a couple times for not allowing short-term rentals in multifamily. So it sounds like it's, and I might have this a little bit wrong, but it sounds like it started in 2015, then maybe again in 2017, and now in 2025. So for about 10 years, that's been the rule. Can you, is city staff able to speak a little bit to why short-term rentals are not allowed in what's classified as multifamily? Is it because of noise, or were there other discussions that led to that?
I guess I can take an attempt at it. I think the interests of the council at the time was actually to preserve multifamily units as long-term rental units. I think that was the reason when they adopted, when they adopted the VHR ordinance, where they allowed existing multifamily units to be grandfathered in and continued. But then when they adopted a new set of ordinance, when Measure T came in, that basically voided all the permits for multifamily units. And then when the council adopted the latest set of ordinances that are on the books today, they made a conscious decision to restrict short-term rental permits on multifamily properties. And I believe it probably has to do with preserving housing stock for long-term rental.
That's helpful. Thank you.
Can I speak to that? I was obviously heavily involved in that because they were going to take my permits away in 2015. So we lobbied and argued our case that we should be able to be continue renewing. I think it was for preservance of affordable housing, which I could agree with that. I think, at the time there was maybe only 40 units that were grandfathered through in 2015. And that would have dwindled down to, I don't know exactly, the city never gave us an answer with this when we were in discussions with the council, but I would guess there's less than 10 units that, like mine, that would currently still be the same ownership and still have been eligible to renew. The city staff put in their suggestions when council was debating that the multifamilies not be included in that, and it was never discussed at council, so it never came up. The condos were grandfathered in, and that was just a line in the code that said condos are exempt and can be renewed, but they didn't include me and maybe a couple of other owners that might have qualified for their multifamily properties. By the way, this definition of multifamily with the shared wall and everything else inadvertently made all condos ineligible for vacation rental permits, which was never discussed at council, was never a priority of council, and just the wording of this made most condominiums ineligible. So, and then, what's my comment? Affordable housing. If I put a breezeway in, all of a sudden it's okay. If I had two separate cabins, exactly the same size and utility on the property, then it would be okay. If I had a house on its own parcel, same size, same utility as affordable housing, that would be okay. So all of these things have singled me out just because this was a duplex, and there's really no effect on affordable housing that isn't being had in other avenues anyway. If you've got any questions on that, I'd be happy to answer.
And you're just applying for a permit for one,
Well,
for Unit A?
the way I read I'd love to get both, and I'll continue to advocate with council that at least the people that were denied in Measure T are able to keep renewing the permits that they did have on multifamily. I'm both ways. I don't think, I kind of agree with not allowing new permits on multifamily because it's a disincentive to investors to just set up little apartment units. It is, however, if I was recommending to someone that wanted to make a life in Tahoe and afford a house, if all options were on the table, the option I would recommend is buy a duplex and vacation rent next door. You'll have a spare space for your family when they visit, and you'll pay most of your mortgage with the rents from that one side. If there was a way to do that through a shared rental sort of program or something like that excluded workarounds and just encouraged a way for people to afford a local house, I think that would be a great thing.
Okay, thank you. Any other questions? No? Okay, so now is your opportunity for any closing statements before we go to public comment and discussion.
I think I've said everything I have to say. I mean, to me, it's pretty clear. It all boils down to what a shared wall is. I hope you all agree with me that a shared wall is a wall where you've got people on either side of that wall that could possibly disturb each other. That seems the more obvious choice to me, particularly considering the different ways they could have written this definition. They could have just excluded the last half of the sentence and said it's an attached dwelling unit, and then I'd be pretty hard pressed to make my argument. But they didn't say that. They could have said it's under the same roofing envelope, but they didn't say that. They could have said there's continuous structural elements between the units, but they didn't say that. They said a shared wall, a shared floor, or a shared ceiling. And I don't think I have any of those things. And I'm prepared to make modifications if I have to, but I'd like a really, really clear opinion of what that is. And then if it's easy and quick, I'll roll the dice against the buffer. And if it's expensive and long, probably not. We'll see where we go, and I'll advocate for at least getting grandfathered in for both units at some point in the future with the council. But yeah, that's my case. I appreciate your time and consideration.
Thank you, Mr. Smith.
Thank you.
Okay, we'll move on to public comment. If there's anyone in the audience that would like to speak on this agenda item? Nope. Anyone?
Go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 4. There are no hands raised, Chair.
Okay, thank you. Moving on to discussion. Does anyone want to start us off?
Nothing for me.
Nothing for me.
I really looked at this case and looked at the evidence, and I want to really think about the practical realities of what it means to approve this kind of permit with the multifamily definition as it is. I think the practical reality is that the intention of the ordinance was to not approve units within one building, right? And I think I can contemplate if we approve something like this where people can internally create a second dwelling by putting a division within their house and putting a gap and putting doors. That's an easier adjustment in your building than tearing down the roof and, you know, separating stuff. So I think what's complicated for me in this is that if we think about what the precedent this creates is, you know, that's what one of the alterations that can happen internally. I mean, I'm not an architect, so I might be oversimplifying that, and I want to acknowledge that. But then the other component is if there's this kind of entryway or whatever we want to call it in the middle, like how big does it have to be for it to then not be part of a multi-dwelling? Is it 6 feet wide? Is it 3 feet wide? Is it 2 feet wide that you can get in to put your rakes and your shovels in? So I do think that the intention of the ordinance was to prevent short-term rentals within multifamily units, and there's nothing that prevents a long-term rental in this capacity. So I think that's where my stance is right now. I'm very concerned with what precedent could set in the approval. And right now, the current tenants are month to month. We don't know who future long-term tenants could be. We don't know if they'd have a problem, if they'd find the noise complaint. The idea was you're under one structure, you know, whether it's a roof, whether it's one deal, it's one structure. So I do think that condos were specifically lined out of this multi-family unit. There's a specific call out in that, and the ordinance as written contemplated folks who had the permit prior to Measure T. As Mr. Thomas said, there was language written there that allowed for earlier applications process to consider these. It got a head start in the application process. I think if council wanted to exclude multifamily units from, I'm saying that backwards. If they wanted them to be able to access permit, I feel like they would have put that directly in the ordinance. And I think if we contemplated because they contemplated where they wanted those exceptions, and they didn't do that in this case. So I think the intention really was this is one structure.
Thank you. Anyone else?
I guess just briefly, I mean, it is like, it's weird technicality back and forth, like decision of what's continuous and what's not. Like, sure, but in that case, and that's why I asked the question about intent. I feel like we have to fall back on intent, and it seems that the intent of City Council was to preserve local housing stock by not allowing short-term rentals in multifamily units. Whether or not that works, that's not our call to make, but it does seem to be the intent. You know, this property, it looks and acts like a duplex. You know, they're all over all of our neighborhoods, and just because this one has a little alleyway in between, that's why we get into this technicality. But I can't really decide, between the technicality of continuous wall. I'm falling back on intent, which seems to be to not allow short-term rentals in multifamily units. Yeah, that's where I'm at.
Oh, I was going to say, I would agree with Ms. Gonzalez with just setting the precedent of what kind of snowball could come along after this with, all kinds of multifamily properties, appealing denials just to work around it. I understand Mr. Smith's frustration because of the definitions, and I think that really needs to be looked at by City Council. I know at the next meeting, they are going over the ordinance, and it needs to be clarified because this is a lot of time spent, money spent by property owners, and when it's not clear, it is, it's frustrating and it costs time and energy, and I think that's really important for the City Council to address going forward.
So, we can't really make judges based upon what the intent of the City Council is. this was poorly written. The intent, because what the intent was to, I've followed this along for, ever since 2015. I had a family member who had a triplex right on Ski Run. The intent of the city council at that time was not to have VHRs in multi-unit housing on one lot. Didn't matter if it was two homes or one home, but it was poorly written. So they wanted to get rid of all multifamily, which is 2 units on one APN. That was their intent. And this was very poorly written. It should have been written correctly. Otherwise, if they would have written it correctly, they would have said more than 1 unit on an APN, which would have excluded condos out of that, because they really didn't intend condos to be, they wanted to continue to keep all those condos to be able to vacation rental out. That was, I can remember that discussion, but it was poorly written at that time, and it continued on to last year. It's unfortunate. Mr. Smith can convert that into a single-family unit, but your contention that people can then make one house into 2 houses, it's really not that simple. Yeah, you have to have an allocation to multifamily unit allocation to be able to do that. Someone can add another door into their house and have lock-offs on that house and rent out that other portion of the house. That's perfectly legal. They can get a VHR permit to do that. I think we've done away with a qualified VHR, so someone can rent out their under the stipulation that you just gave. They can actually put another door in and have access to it, and they can rent that portion of their house out. It's a poorly written. It's poorly written, but you do. Even though they have a way in between, I'm kind of one way or the other. I'm not quite sure how I can vote on this one.
Discussion? Does anybody want to make a motion?
I'm not able
You're
to
not.
make a motion.
Okay.
I can try to make a motion. I don't quite know how to do it in this process yet. But it's in the staff report, right? The one.
It's actually,
Okay.
there's a draft resolution, and if you look on the agenda, there's a proposed action, and that it would include a suggested,
Do I read it this one or this one on the agenda?
the one on the agenda is all that's required if you choose to do so.
Okay. I make a motion to pass a resolution making all findings set forth in the resolution and denying the appeal on 2480 Conestoga Street, Unit A. Was that? Okay.
I'll second.
Okay, we'll go ahead and take a verbal vote on this. We'll start with Chair Luxinger,
Yes.
Vice Chair Feiger. Yes. Commissioner Imhoff,
Yes.
Commissioner Williams, and Commissioner Gonzalez.
Yes.
Okay, that motion carries.
Thank you, Mr. Smith. Okay. We are going to move on to our vacation home rental ordinance discussion. Very timely. And I believe Mr. Feiger has a working list that we started at our November meeting.
Madam Chair, may I just make a couple comments? As you said, this is a discussion that is at the request of the Planning Commission to discuss the upcoming vacation home rental ordinance. It's being considered February 10th by the City Council. And and just to bring back some of the items that you did discuss or had concerns with, one that we did notice is, the lifetime ban. If you get 3 strikes, you're off the list for good. The other item was potentially creating a preference class for individuals that have been buffered out, that were eligible for vacation home rental permit. Another issue is the serial citations, getting multiple citations on a weekend, and then the applicant not getting notices till weeks later. And then, as you discussed in this most recent one, is, the definition multifamily. I'm not sure if you had a chance yet to see the agenda that the city council is considering for the vacation home rental ordinance. There's 2 versions that are being discussed. Version 1 would replace the 150-foot buffer with a cap of no more than 1,200 VHRs. It would also create a minimum age of 25 in order to rent a VHR. It would exempt attached condominiums. They would be allowed to get a vacation home rental. Currently now, you could only, attached condominium can only get a permit if they had a permit as of June of 2016. If they didn't, they don't qualify, so they're removing that. They're also changing the appeal process. Appeals would not come to the Planning Commission. It would go to a special hearings officer. And they're also changing the standards for vacation home rental permits, single family in commercial and recreation areas would be treated similar to how we treat vacation home rentals in a tourist court. So those are the main proposals for version 1. Version 2 would replace the 150-foot buffer, not with a cap, but would not allow VHR permits being adjacent to each other. And all other provisions of version 1 would stay in place. And I hope that will help you in your discussions. Thank you.
Thank you, Mr. Hitchcock.
Sorry, Mr. Hitchcock, you said there was a second comment. I didn't catch what the second one was.
The second version is...
No, not the second version, your initial list with the lifetime ban, serial citations.
Oh, I'm sorry, lifetime ban, preference for parcels that are buffered out, that were eligible, serial citations, and then the definition of multifamily, which came up at the last appeal.
I think that I would prefer that the appeals continue to be to the Planning Commission, because we did approve 2 appeals. And my feeling is if it hadn't come to the Planning Commission and went just to a hearing officer, that they probably would not have been approved. I think it's taking the Planning Commission out of that. It's been so slow on any other thing, and it's been slowing down. We only had 2 appeals this time. I would like to recommend for us to recommend to the City Council that we continue to do the appeals. I want to find out if anybody is willing to consider that.
Yeah, I think I would be open to that as well. I guess it would just depend on how they would, is it just one hearing officer that kind of reviews information and it's a yes or no? And is that fair to the person that's appealing? And they're spending quite a bit of money to do the appeals. So I think it would be fair to have a multiple vote situation and different ideas and opinions involved versus just one person that can kind of make or break it for these people. So
And then they're just, going through the motions. And so.
whether it's.
Chair, I could speak a little bit to
Okay.
the hearing officer. So other staff, correct me if I'm wrong, but I know we're in the process of, we have an RFP for a hearing officer, which I believe that would be involved in these appeals as well. The idea is we would have a group of hearing officers that we would rotate through, so it wasn't just a single hearing officer, which we currently have for other citation issues in the city. So that's in progress. We haven't picked one or some yet, but that would be the idea.
Okay. So, but would it still be just that one person, whether, they're rotating, but just one person per case?
That's
and they
correct.
would, okay.
Yeah.
Okay, thank you.
Does that RFP have a list of qualifications for the hearing officer?
It does. I
Can
don't
you-
know them offhand.
Is it related to like knowledge of land, like just background, like education? Do you know any?
I can't speak to that if it went to it, but it's related to all code issues. So they would have experience in those sorts of things. But as to land use specifically, I can't say that I know if that was in there.
I say this with potentially pushing myself out of a job. I think one thing that would benefit having hearing officers for people who are applying for VHRs is folks who are knowledgeable on how to read and apply ordinance and interpretation. I do think that the law is never, it's not a surgical knife. And it never is. No, depending, I practice in a lot of areas of law, it's a blunt force object, the law, and how it works, no matter how it's written. Someone's always going to get cut out. Someone is always going to benefit. It's just, there's so much subjectivity in legal interpretation, which is really hard. So I think there is a benefit to having hearing officers who are knowledgeable in how to interpret and how to understand the application. I do think that it is a concern, you know, when we have when the commission has had certain conversations related to constitutionality that don't apply in the consideration, and they are being contemplated as part of the decision making, as opposed to being recommendations that we could talk to council later about why this isn't working as a blunt force, why this is working as a blunt force object instead of maybe the way that it was intended. So I say that. I just got it, just had my first hearing, so I want to recognize that I'm pushing myself a little bit out of a job. I do think there are a lot of benefits to having, you know, your peers hear this too. So I do see both sides, but I didn't want to also ignore the fact that hearing officers potentially could have experience in a way that also benefits applicants.
I think that's a great point.
I too agree with Ms. Gonzalez, because it was never the intention for this organization to hear appeals in this matter. And I think it would be better served in somebody who really knows what's going on with a lot of the issues within what we're dealing with today.
Mm-hmm. Good point.
Honestly, I could go either way. If city council's doing it because they don't think we're doing a good job, that's like, doesn't feel great. But also, if they want us to continue doing these, like we should probably get trained on actually get trained on the ordinance instead of like relying on our self-education and experience through these meetings. So
I think
so. Maybe it might be just cleaner to go to hearings officer.
I think that most of us are pretty well versed with the BHR ordinance. We've gone through it for the last 6 months, you know, with the appeals, and the appeals are slowing down. I hesitate to because we're learning stuff to be able to make recommendations, and without this process, we could not make these recommendations. So I'm still want to make the recommendation that we continue to keep it for now. And if they do get rid of the buffers, most of these appeals drop off. Most of the stuff that we've been handling are things with buffers.
Well, and from what Mr. Hitchcock described with the two options that they're considering, it sounds like the buffer will be restructured, I guess, in the second one, completely removed in the first one with a 1,200 cap, and then replaced with just no adjacent properties.
No
Is that
adjacent properties, correct.
so? That would probably, yes, take out a lot of appeals.
We don't know what the new city council members going to vote. We do know that there's two who are against any kind of change at this point. And it's going to be up to Heather, our new city council member, to decide on where she's going to go, or if she's just going to leave it the same.
Well, looking at time here and thinking about our agenda item that we're on, you know, this is some new information that we weren't, that, you know, I mean, the agenda came out today. I didn't get a chance to look it over before I came to this meeting, but, you know, this is some new information that we're getting today regardless. So, I don't know, the best way to approach this, because I was kind of thinking, like, I had a list of what our recommendations from October that I think were transmitted to City Council, but it was also Natalia was going to go give the presentation in the next evening meeting.
I can answer that question too, because Natalia did
Okay, great.
get up in front of the City Council. She did an excellent job. There was only one question from David Jenkins, from Councilman Jenkins, and he said, "Do you have all those written down? Can we get a copy of them?" And she said yes, and I'm sure she probably sent them over there. And that was last October that happened, okay? So anyway, but she did do all those and put down everything that was said, because I wasn't attending the city council meeting, but I did see it on the tube, so.
And I looked back at our meeting minutes from October and saw the 6 listed out specifically, so we could, just reference those again. So this agenda item was to come up with either recommendations for city council or just like what we're seeing, like the reason we're seeing so many appeals. We don't necessarily have to have a recommendation, but like this buffer rule is causing most of the appeals, we could say. And I think it's good information for council because some of them are watching this, but not all,
Yeah.
Anyway,
and
so,
I
yeah.
think just some of the little nuances too, like the definition of multifamily needs
That's
to be
one I had, yeah.
defined better. And then I think our other points that Mr. Hitchcock brought up earlier was the lifetime ban if there's 3 strikes against the property. But there was also another case that we saw that had a lifetime ban, but it wasn't for 3 strikes, if I remember. It was like one of our first
And
appeals.
it was also some of the strikes were like very, very minor.
Right.
Not having something in their ad works. and
Oh,
things like
yes,
that.
it was, like an online advertisement.
What was it? It was also too some duplications where a person got cited for basically the same issue.
And then the
And
owner
then
also got cited.
they counted as a
Yeah.
strike against them.
I think part of it was their renter would get a fine
Yeah.
and not pay it, and that was counted as a strike against them, and they didn't know, so they applied and like, what, my renter never even paid that?
And it counted as
It
2,
counted
because
as-
it was one against the
yeah.
owner, one against it, yeah.
So those were all things that we already communicated to city council, I believe. We could reiterate it if we want to.
I don't know if they've been sent to them,
Maybe we should
via
do a
correspondence,
new- yeah.
but David Jenkins did say that he would like to see. Nobody else responded, by the way. I mean, there wasn't any questions or anything like that. After,
Let's just resend that list from those October meeting minutes, if that sounds
Okay.
all right.
Yes, and I think we need to add
And then-
that the definition of multifamily needs to be better.
There were 4 things that I wrote
stated.
down during the discussion to potentially add that I could start with,
Yep.
and then as discussion. So multifamily definition was one.
Sorry, before you go off the list too, I'm wondering if, just for clarification, if we can make recommendations that are administrative versus things that would be codified, because I think that might be something that, and I don't know, Dan, if we can make administrative recommendations that could be like cleaning up the application, for example, as a certain way, or like making sure the inspection list is available ahead of time so people know what they have to inspect. That doesn't have to be in the code itself.
Yeah, so it's this isn't a resolution or any formal action, it's just passing along a recommendation. You can recommend whatever you'd like.
Sorry, I just wanted to hear that before we looked at your recommendations so I could sort them. Thank you.
And Chair, really quick to also answer some of the questions I think I heard in that statement. If there are administrative suggestions that the commission has, those can be brought directly to staff. For example, the checklist. That is available ahead of time. So if there's clarifying questions or administrative suggestions, feel free to pass that on directly now. It might be things that we already do. It might be things that we can kind of easily alter that wouldn't conflict with the ordinance or anything. So I just want to offer that as that's the potential right now. I wouldn't have to wait to necessarily come.
Sure, that is another option.
Great.
So I'm just going to list the 4 I captured, and then just we go from there. So there's actually one from last month or the month before where we had a couple people that had hosted VHRs that could not transition to non-hosted, like full VHRs because of the buffer rule. And yeah, so we were like kind of looking for a path forward for them potentially because they've been operating in good faith. There will be no difference in how they're operating. You're like, they're already there doing it, except for, so if they have a clean record. So that was one of them from past. And then the 3 I captured from today, multifamily definition, as we just talked about, continuous wall and so on. Sign standards could be as straightforward as font size and ADA accessibility. And then the third one today, fourth total for new ones, is potentially that inspector training consistency. Maybe that's just something that we mentioned that we heard, that there's, we've had complaints about inconsistent inspections. Maybe just pass that on. Anyway, those are the those are the four things I captured. So
There's one other that I was thinking about with respects to apparently that, in the VHRs that you have to have them managed professionally, correct?
I don't think
No.
so. No.
Oh, it's
You
not?
have a local
No.
contact.
Oh, okay. I
Correct.
thought they had, no, I thought they have to be professionally managed.
No,
Really? Okay. Maybe I missed that one, so.
that was a proposal multiple times, but it's never been put into.
But you
It
have to
has
have
not
someone locally that's an available contact for.
Right.
And can
Any
respond
issues.
within like a few hours
Yeah.
or something.
Now, I'm talking about the VHRs, not talking about the hosted rentals.
Yeah.
Right, yes.
Okay.
Yep.
All right.
Same.
Then that's.
You have to have a local contact person on VHRs.
Some food for thought, I don't think there's any question about that this 150-foot buffer has been agonizing for us all. It's been really a problem. And, these people have jumped through hoops. These people spent a lot of money and stuff. And if the buffer is not changed, in other words, if it is as is there any thought of maybe making a suggestion to the city council that the prior people that were on this priority list be granted a waiver in order for them to get their permits? I mean, they spent a lot of money, they spent a lot of time, and we did say priority list, but we've had so many of them that we just rejected this. I don't know.
And that was actually, I think, number 2 that Mr. Hitchcock mentioned when he went over our list, that we did have hope for a preference list for the parcels that were buffered out and the appeals had to be denied. So I think that is important to bring up to city council, because there is probably 10 or so that.
we know of that appealed. Probably
Right.
Yeah, there's a lot of them
Right,
that
and
probably
others that
haven't
didn't
appealed.
appeal, exactly.
And if they do get rid of the buffer, like
that's it.
they already did and it sounds like they're going to pretty much no matter what. Like I agree, they've already done their application. It's already been deemed complete. They've likely had their inspection or at least scheduled for an inspection, so they're like ready. You
Right.
know, yeah. I agree that all that effort should be considered.
I'm wondering, well, I have two questions since you all have been here for 6 months doing this. Is the problem with the 150 buffer because it's new and that people are getting used to it and having to deal with ramifications of a new statute, or is it because it feels arbitrary because it is new? Like, or is it just the technicalities? Like today we saw the one with the encroachment that was really small. That feels like a really rough technicality. Like I know that if that was me, I would feel really burned by that. But I guess I'd like to hear from you all. What do you think the 150, like the main contention that you've been dealing with on appeals?
It's making us choose winners and losers, and it doesn't have we can understand if there was a lot of complaints about noises from people in the different area, but from what we've been able to tell, there has not been a lot of citations issued. So even in the past, when they had it's never been as much of an issue as more of a perception on the behalf of neighbors not wanting to. One of their major things, I don't know who's in the neighborhood. That was a big complaint.
Well, I think, can I just
Go ahead.
bring out real quick? This conversation is important. Obviously, we've had a lot, but it's not really up for us to decide in this capacity whether or not we think the buffer is a good idea. What we're saying is we're getting the majority of the appeals we're getting are because people are buffered out. So and their applications are done, they seem like nice people. They have a clean record for the most part. So to city council, for this agenda item we're on right now, it's like, if you do get rid of the buffer, these guys already have their applications done. Look at them first. Is kind of all we're saying. We're not discussing the merits of the buffer rule. Is this commission?
No, that's helpful. I think as you're talking, one thing that is contemplated in other kind of administrative law areas is wait lists. So because the permits expire, at some point, and there isn't, I think with a cap with these adjacent, there's always going to be winners and losers because it's still going to come down to first come, first serve at the end of the day, if you boil it down. But perhaps the people who have what are essentially complete applications with no citations, like good operating, can be, because the issue with, right, the Measure T and the constitutionality was who's prioritized. But if people have already filed applications, getting in a wait list isn't so much about preference. It's they did it, they're next in line for the next available permit. So that would be another way to consider it without thinking about just like who should be prioritized. Like the people who, I think the people who should be prioritized in theory would be the people who did the process correctly, which sounds like those are the appeal issues that you're dealing with. And this could be a proposal that softens that blow.
That's a great idea too, just with the wait list and, then somebody has like an actual number, they're number 13 on the wait list and.
Well, the wait list is kind of unworkable because it's going to be, it's not so much 113, or if you're talking about the cap.
It could be with the cap if they go that way.
But as far as on the buffer zone, with the buffer zone, the wait list is useless because it could be years before somebody else has it, but another person who's 50 on the wait list all of a sudden can get theirs because they're no longer buffered out. Right now I think we have 550. How many do we have approved now?
I'm not aware, but.
It's in the vicinity of that.
And then there was like 250 or so that were buffered out?
Yeah, if you give me a second, I can look up the latest stats that the CSO division.
Yeah, so, I mean, we're not even, and my understanding is we may have 100 that are still waiting to get their permits. So we're not even close to that 1,200 unit at this point. One of the things that I'd like to see on the, go ahead.
I have it here. This is as of January 8th, at least, the most recent update. 1,256 total applications. 556 have been issued. The buffered out number is 268.
And then how many are still?
There are 133 that are accepted, and they just haven't scheduled inspections. So there's 133 that we're just waiting for them to schedule inspections.
Yeah, so just the 250 and the 260 and the 550, that only puts us at 800. And then
there was 479 that were rejected for any number of reasons.
It could be too many.
It could be everything, anything. It's just they didn't even get to the inspection stage. So it could be that they didn't own the property, it was multifamily.
But how many were done because we were, like we had a couple of them that had a lot of strikes against them.
Yeah.
So that probably is in some of that 400.
It's a lump sum number that's provided by the CSO division. It's 479. It's just they never came to the inspection stage. They were just rejected at the application stage, and the reason.
And that could be because they have too many strikes.
It could be for that and
or other reasons.
Yeah.
One of the things that it came up today again on Ms. Jackson's appeal. Can we add into the list of things that need to be submitted deed?
Can you repeat that? I'm not sure I understand.
Can we add into the list of things that need to be submitted for the application, the deed trust?
That is currently considered.
Yeah, that is in the application requirement.
I know, but before the inspection comes in.
Correct. That's part of the application requirement.
Okay, because it wasn't on Ms. Jackson and one other one that we had where we approved the appeal because the person who got the permit that buffered them out didn't even own the property at the time.
Yeah, so there's a requirement for proof of ownership.
Okay, prior to the inspections.
Yeah, and basically what happened with, for example, Lorraine Jackson
Yeah, so with-
situation was the
Yeah,
trust, right?
Was, because she changed the property into the trust, and then when she submitted the application and submitted the deed to Community Services, they basically looked at it and then compared it to the original permit that she had pre.
Oh, because she was under the expedited one.
Yeah, the original
Okay,
permit was under
the
her
preferred.
name, Lorraine Jackson, but then when she submitted an application and her deed of trust, the new one, it was a living trust, and that's what caused CSO to put the brakes on her application and go.
Because she was under preferred.
Yeah, please provide us additional documentation that you actually own this trust.
Okay,
That it was the same person.
so we
from
have
before.
made it so that you've got to submit the deed at the time of the application. Okay.
It's required, yeah.
And then someone was saying something about ADA. I don't believe that these are required to be ADA.
No, I was talking about with the signage, there's some standards in ADA compliance of like, you use white and black font for visibility. Like, so it's not about like having, it's just general standards that the ADA offers for general compliance for like things like a website or other stuff, and that they could be used to either, I think that to me is a more administrative than a code type stuff, but as an example of like what the city could use as a template for.
Oh, okay, so
for
you weren't saying
standards.
that they need to be ADA compliant.
Well, like because the idea of legibility, when you do ADA compliance, like can't really do red and yellow like on a background. That's like considered like people who have visual impairments can't see that. So it helps to standardize legibility in certain ways, certain fonts, sans serifs, things like that. So I was offering it as a suggestion for the city to consider in their template or the language in the application that might be helpful for people to understand what legibility means, because that seemed to be not clearly defined.
I was misunderstanding that you're trying
No,
to
it's
say
a good
that they need to be ADA compliant buildings, and I'm going like, that's
I
not
can
required.
clarify on that. So the city we do have templates that are available to download from the website. The sign, the dimensions that we call for these signs are 12 inches by 12 inches, so 1 square foot, with white backing, black letters, sans serif font in bold.
And I think
And that's
also how many
available, yeah,
inches,
and that's
too.
available on our website.
Can I ask a question about the process when you guys get applications in? Because I think one of the really problems that we've been having on this buffer is the fact that people are put on a priority list, they do all the work, they spend all the money, and then they're rejected. So like when these applications come in, like this application comes in over here, it hasn't been, I guess, totally approved yet, and this one comes in and hasn't been approved. Is there any way to communicate that, hey, you're going to be buffered out if this is accepted, so that you don't have to spend all this money? Because these people spend $5, $7, $8 if they have to do any
But
improvements
hopefully
and
that's
stuff.
gonna.
What's
go-
that?
Hopefully that's gonna go away
Yeah,
anyways.
I understand that, but I mean, just the process in the application, because I think that's been a really,
It's confusing.
it's been really a problem for when you tell me, hey, you're on a preferred list, and I go out and I spend $7,000 or $8,000 to be buffered out.
And they're
I'm
within,
mad.
they
But
applied within like
They were both on the
hours.
preferred list.
Huh?
They were both on the preferred list.
I know it.
And their applications were
I
within
realize
hours of
that.
each
I
other.
realize
Yeah.
that. But I mean, is there the communication there as far as, okay, hey, Steve, you know what? Somebody else is in before you. I mean, you could be buffered out. So, I mean, should I go through my inspections or not?
Or Steve, speed up.
Right? I get it.
We do
But-
have the map that you can check now to see if you're
Well,
buffered out, so.
actually, let me
Oh, really?
clarify on
Okay.
it. There is a map, but the map just shows properties that have been issued permits and approved. It doesn't show pending applications. I don't know if that's an administrative process to do something like that.
So again, under the code, the application process is handled through the CSO division. And I do believe they notify when there is another kind of applicant in the running, if you will. Now, to your point, it's not like a real-time update, like, hey, they're way ahead of you, or they're kind of the same timing as you. So yeah, that's a point of, I think, confusion for everyone. It's like there might be knowledge that someone else is trying.
But if there's 100 people waiting for an inspection.
It could go on
then-
forever, right?
yeah.
There's 133 that haven't even scheduled inspection, so it doesn't provide that much necessary information. You have some sense of it. but-
Hopefully, it's a moot point, get everything taken care of, yeah.
So sorry, we got a little, we were kind of on that signage one for a second. I was interested in something Mr. Hitchcock said, that there are templates you can download, white, black, but you're not required to. Is that, so that you end up with this green one that people could or could not read, is why we're talking about this today?
Yeah, the code doesn't specifically talk about the standards for the sign itself. I believe it just says it has to be legible. So we created templates based on the old signage, and it's good size. It's, has black bold text, and we always encourage people to put those signs like on their garage, the facing garage, as opposed to, by the door.
So is this one of those potential administrative fixes where you're required to use the template and put it where you can see it from the street?
Yeah, I mean, that was going to be
That
my
seems
question
really
then.
straightforward, potentially
Right, because if they're
straightforward,
not
like,
using the
yeah.
templates and it's still legible, I think either adding into the code at like something as simple as using
This template.
Only city colors
using the
and-
city
yeah.
template or something like that. So if the city decides, or if the ADA standards change, the city can update without changing the code. But something about, or either that or putting it in the inspection list that what we are looking for legibility is something like the template. I can't figure out whether it's quite code.
That is in the inspection list.
Right, it's, what's in this inspection is the sign is legible, but not necessarily, again, what defines it as legible.
But on the links, it is in the links.
Right.
Right.
But it's
But,
like an option, not required.
so I think that's, with the standardization of training too, that's the hard one, I think. And in fairness, I'd like to remove some of the subjectivity about that from inspectors. So inspectors are working with a rubric on what that means. Do you know what I mean?
Yeah, I can add some kind of maybe points to this. I have the checklist right here, and honestly, it's tricky, right? So you have to have an exterior sign posted on the outside, visible from the street, legible, and not to exceed 12 a foot. So it's like this. It can't be this giant come to my VHR sign. It can't be bigger than a foot, but it also has to be legible. It's almost like an impossible balance to reach. So
If you're set back 30-foot driveway, what do you?
if your house is set
Then you
back,
can't.
you're not
Then
going
it's
to.
not
It's
legible.
impossible, yeah.
And if you have exactly, so it's a very challenging point. It's a very challenging point for the inspectors because it can only be legible to a certain distance, and it can't be bigger. So it's a challenge. And so yeah, there could be recommendations though about maybe it's based on a setback issue, like if your house is set back more than 30 feet, it can be bigger or something. But right now it's just this very kind of rigid thing. Yeah.
I think it just required me to have it used to be before Measure T, everybody had very similar signs, and I don't know if that was by requirement or just how it happened, but you could just
all
walk
with
down
the
the
same
street.
company.
So so you just make it required, so even if you see a little white sign, even if you can't read it, you know what it means,
Yeah, you can speculate that it's
Yeah.
it's a VHR.
Yeah.
One of the things that it was brought up here when somebody had two different inspectors, one was easy, one was very difficult, is the problem that we're running up against is this is an outside company. And they're not trained, well, they may be trained, but, they don't have anything in it.
Yeah. Yeah, no, we use a third-party company as approved by council, and they're trained in uniformity. But I think again, it's this. There's some regulations that you almost can't win on, in the sense that it has to be legible, but it can't be bigger than a square foot. So if it meets one component of that, again, you can't speculate what a certain inspector is thinking at the time, but reading the code. If it fits that sign size, they can't make it bigger. So there could be some situations like that where it's just simply challenging with, as you point out, Commissioner Gonzalez, with laws, there's always some, they're never perfectly written. So regarding the inspection service, it is currently a third party due to the kind of staffing, the ramping up, as you were, of conducting these hundreds of inspections. And there was a training program to provide training on all these components, including defensible space training by the fire department and so forth. And any code issues are verified with, building staff and things like that regarding building code. But yeah, hopefully that provides some clarity.
I actually think that this sign one is the first time we've had a claim of like inconsistent inspections. So maybe it's really more of the sign issue than the inspectors. So, and I guess, so is that something that we should like pass on to city council? Or is that something that like planning staff can take a crack at, like some kind of sign standard?
I would agree. There hasn't been a significant issue with inconsistent inspections. And again, I think that kind of discussion came up with the challenge of having legibility, but you have to have a small sign by nature. So it's a hard balance to strike. So maybe some recommendations about how big a sign should be, what legibility is defined as, and if a house is set back at a certain distance, but the sign can't be bigger than 12 inches by 12 inches, legibility will be hard.
Or maybe what you do is, in your checklist, if you follow our template, you won't be denied.
Well, they could be denied for something else, so you don't want.
No, you won't be denied
signs.
because of signs.
Okay.
You know what I'm saying?
Or
Obviously,
or the city could just require that one of their templates be used.
yeah.
My recommendation would be the city just requires a 1 foot by 1 foot, requires the template that you're gonna have to be used, just period. Would be my recommendation if we're gonna do one, but I'm interested what others
I
think.
agree too, because I think the thing with anytime you have a human person making decisions, it's just going to get interpreted different. So I think to make it easier for the inspectors to have consistency, having the city.
Sure.
Yeah.
Yeah.
Takes out the guesswork.
A template of, I would.
Use our templates, that's standard.
The template talks about, the size and as John points out, the kind of color on color situation. It's not necessarily required per se that we use a template, but what the checklist says is that it just simply can't exceed 1 foot by 1 foot. It is what I just read. So, I'm trying to think if it would probably need to be in the code to say that you have to use a standardized sign template. And so if that's a recommendation of the council, I would recommend that would be suggested for actual codification.
Would you recommend it be bigger than 1 foot?
Well, I guess it kind of goes
Because
to.
it's not very big.
It's not very big.
Yeah.
It's like smaller than this piece of paper, really.
That's
And
11, that's 11 inches right there.
and so,
11 and a half.
yeah, roughly. So, again, if your house is set back 20 feet, this is pretty big. If it's set back down a 100-foot driveway, it's tiny. So, it could be that, again, this issue hasn't come up a lot. This is probably the first time I'm really aware of it out of the hundreds. So I don't see it as a common issue, but there could be instances that the commission could recommend to say, hey, it's a sliding scale. I wouldn't get too specific, but you could say if the house is set back more than 50 feet, something like that. Most houses aren't in the city. Most aren't. Most 20, 30 feet. It could be that if a house is set back by a large distance, then the sign could be enlarged to 24 by inches or something.
I might recommend that just be codified as whatever template the city sets at the current time, which would allow the city to city staff to adjust the template if over time they saw, this 12 inches is enough. So if you just said whatever the city template is, you allow the change without having to go back to code and change every single time.
I don't see it as a reoccurring issue, in my honest opinion. This is, out of hundreds, this is the first time it's been an issue. I don't personally think it needs to be bigger than 12 by 12. I think that would distract from the aesthetics of a neighborhood personally. So I would maybe just caution against that. But again, it's the commission's choice to what the recommendation is. But again, I don't see it as a major problem. But I do like the idea of using like a standardized template. It gets rid of ambiguity. It helps with that kind of, makes it easy for everyone to agree on what the requirement is.
Makes it easier for inspectors to find. I mean, just like,
Yeah.
it used to be able to pick them out easily,
Yeah.
for better or for worse. But, I think.
I'm not sure we want to codify at this point, because if this is going in front of the city council on Tuesday, to be able to put this, we can't put it onto the new ordinance, and I don't want to hold up the ordinance coming forward, because if it passes this first reading and goes into a second reading, and we bring something up, they say, oh, well, let's add that, then it's going to push off the first reading.
I believe it's February 10th is the date that it's going.
So are the recommendations that we make going to be a part of the commissioner report on the city agenda? Or the
So
council agenda?
that's how we did it last time.
Okay.
That's how we could do it. If you all did have written recommendations, you could do it that way as well, and submit that to council in advance of the meeting. But last time we did do an oral report to council, and you could do that if you'd like.
We can actually do that at every city council meeting. There's always a portion where they can say any reports out from right?
I think,
right. Yeah.
Yes, every city council meeting has a section towards the beginning of the agenda that allows commissioners to give a verbal report on what their commission has been up to.
Okay, looking at time, point of order. So if we do send, I mean, I guess how baked is the thing for February? If we do give them any recommendations, is there still time to incorporate it, or is Commissioner Williams saying there's no point because they've already got it very well baked?
And then is it going to stir things
slow-
up?
yeah,
and
stir things up,
slow
slow
down
things
the
down.
process?
So at this point for that meeting, I don't believe they could choose to say, okay, we're going to not adopt a first reading of this, and but yeah, I believe it is a first reading going on for the February 10th.
Yeah.
Can John or Zach
I
confirm that?
guess the question is how baked is it?
Okay, yeah, so given that, if there was to be a verbal report on that date, they could say, okay, these are good points, we'll have to hold off, or, it would be too late for them
If we
to.
send something in tomorrow, is there still time to adjust, if they choose to incorporate anything we bring up into that first reading, or is that first reading, how far along is that?
Well, it's
Like,
cutting it
give
pretty
use of
close.
our time, okay.
It
It has to be noticed.
Yeah.
Today.
Well, so this is a report to council, so could we distribute that to the council members in advance?
In the public.
Well, yeah, I would say that would be tough, for a couple reasons to do at this point.
There's noticing requirements.
Well, yeah, I mean, they couldn't, if the bottom line is, could they make the changes now into their ordinance this on? No. There's not gonna be a public meeting where they could do that. So no.
Is there a way to give them written report on this thing individually so that they can kind of grasp what we're talking about?
Yeah, so
Because it seemed to me when I was watching the city council meeting and Natalia was doing such a good job, I was looking at some of the council members and it seemed like it might be going in one ear and out the other. So, I mean, if they can have this in their hands and study it for a little bit and then bring that up, it might be to the advantage.
Yeah, so we could do a written report. So that would require the commissioners to agree on the language now, and we could have staff draft that and distribute that to the council members. In terms of the timing on that, I would have to look into
See, I'm
that.
not even sure if Natalia wrote that up, because if she said that she was going to give them that already in October, so I don't even know if they have that.
My recollection is we came up with some specific bullet points
Some
for her to
bullet points,
read.
At
So
the
I think she
meeting,
had a script. I don't know that we agreed on specific language for a written statement, but I think we had a bullet point script for.
I think we didn't do a written statement. It was just in the mindfulness of timing and time, because,
Kind of like this.
yes, exactly.
I would prefer not to muddy the waters for this next Tuesday's meeting. Not give them any other reason why they hold off on doing a first reading if they are so inclined to do a first reading. But if they decide not to do a first reading on Tuesday, then maybe we can do a report.
So is there another council meeting in between the actual reading of there's a council meeting next week, correct?
On Tuesday.
And that is not, there's
Yeah,
no
that's correct.
VHR discussion?
That's
Okay.
There is VHR.
It's on, that's on February 10th?
It's not on this coming Tuesday's agenda.
It's February 10th is the VHR discussion.
Yeah, February 10th is the first reading. And if that passes, then the second reading would be February 24th.
So I guess would it be worth it to give an oral report?
So there's
at the
commission
upcoming
reports,
meeting?
exactly,
Yeah.
at every council meeting. It could, if the council, if the commission chose, they could give a commission report at this Tuesday's council meeting. To the assistant city attorney's point, in terms of, rolling anything into like a first reading, the issue with that is the timing associated with public noticing and everything associated with a first reading draft. So, that's not to say that commission reports aren't the commission's right to give and welcome by the council. So it's just the issue is whether or not to kind of work that, on the February 10th. So
Maybe we should see if we're still in the appeals game after February, because they're going to decide on February 10th, 24th, if planning commission is still going to get appeals, right? That's part of this whole thing. Is that
I don't know, that was specifically in the one for.
Yeah,
That will be considered.
So maybe we wait till February and see if we're still relevant in the discussion.
It'll probably take them some time to set it up, too,
They're
though.
taking out the appeals, but we can still make recommendations to the VHR
For sure.
ordinance itself.
I think there's still some points that need, like, just definitely things need cleaning up and clarifying, just from a administrative kind of perspective. So, but, yeah, we don't want to muddy the waters.
No.
Well,
Anything else?
do we need to make a motion if we are going to do something, or are we just?
If you want to bring any recommendations to council,
Okay.
then you should make a motion to get consensus on it.
Okay. What does everybody think about bringing it to council? Or do we wait? What's everyone's opinion?
I think we wait.
I don't think they're gonna pay too much of attention until what time they've got this other stuff handled, quite frankly. I don't know.
Yeah, I mean, if there's no chance of recommendations
Being considered.
Yeah, being considered, then the time's not right, because then they'll just forget them and.
They could choose to consider it, so they could decide to hunt off the first reading if they
They're not gonna
chose,
hold off
but.
the first reading over like the process for buffer or multifamily definition, or, yeah.
I'm not saying it's realistic, but it's.
Okay, so we will pass on making any kind of motion. But
Can we-
great,
can
good
we-
discussion.
Can we agendize this for, I guess at the time you'll be off for February too, because we're gonna have it before the February, will be before the February council, the second
The
February
second
council.
reading,
Yeah, we'll be
right?
before, our planning commission is between the first and second reading, right? Yeah.
I think we have this automatically agendized, at least that's what I was told.
Maybe we
didn't
leave it
decide to
on
do
because
that.
we can always
Yeah.
just,
That actually was going to be a question for today. So
we did
my
decide
understanding
that.
was that was not decided or, addressed the last meeting. I wasn't here, but that's what I've been told. So that's something that we can consider during commissioner reports today, if we want to put this on for a standing item for planning commission meetings or not. So we can talk about that at that point.
okay. So with that, let's move on to updates and announcements from staff.
Well, I think he was asking.
Oh, are you
Well,
asking?
no, I was saying that during commissioner reports is when
Yeah.
we could get someone who put it on and a second to put it on for later meetings, and we can just put a standing item on if
Okay.
if everyone wants to.
Perfect. Any announcements?
Yes, let's see, so the next meeting is February 19th.
Oh, actually, sorry, before we move on, I don't know that we took public comment on that item.
Oh, is there anybody in the audience that would like to speak on the vacation home rental ordinance discussion? Yes. Come on up. Thanks for waiting that out.
All right. Hey, my name is Blake Hershaft, Tahoe City. I've been there about 10 years. Firstly, thanks so much for taking the time for the people making appeals. That was really awesome to take them into consideration. I own a home in Tahoe City. My wife teaches first grade at the school down the street, and I'm never leaving. I'm really struck by your priority here, the number one, the North Star that we should be thinking about. Ability for everyone who works here to live here. I'm the co-founder of the first housing forward Airbnb alternative in the U.S. We're called Fairway. That's stayfairway.com. We're publicly launching this spring. What makes us different is that we only allow rentals that don't take away from local housing stock. We have a whole framework, 6 categories that we allow. What makes us unique to the regulatory discussion is that we're the only people in the room with a financial interest on both sides of the equation, making sure there's more housing and also making sure there's a lot of vacationers. Before moving here, I sat as chair of the Ocean Beach Planning Board in San Diego, and I dealt with all these issues, so I totally feel your pain. Countless hours I've spent on this topic, and I see you doing it now. My recommendation today, and I think you're going to do nothing, so that's all good. I would have moved forward with some administrative things. Also, I would recommend that the council take some time and be a little bit more strategic. Everything here feels, here we go. I won't take all that time. Everything here feels really piecemeal and reactive, and I understand why. And that's why you're having all the problems that we saw right here. Removing the buffer alone is going to displace housing for over 500 people. That includes lifties, ski patrollers, nurses, and city staff. So the buffer removal seems like a bad move in my opinion. Also, the buffer is probably not the right move in the first place. It was super reactive. A win here is 5 votes at council. Now I'm kind of talking to city staff. You really need to be more strategic. I would recommend being more strategic and taking a better approach when you're adopting policy like this. So that's going to be something like forming a stakeholder group, having 2 meetings with the stakeholder group, going into council for a study session, sharing that stakeholder feedback, coming back here, then making recommendations. That's what I would do. You could do it in 6 months, and then you wouldn't have to do this every 3 months for the next 3 years. You could get it done in 2026. So that's my recommendation. Either way, thanks for everything you're up to, and thanks for having me.
Thanks for being here. Okay, any public comment on Zoom?
We do have one hand raised over on Zoom, Lorraine Jackson. Lorraine, if you would like to unmute yourself.
Sorry about that. I'm unmuted. I just wanted to say I'm still here. I've been listening to you discuss the upcoming advice for the city council. And, if I'm not mistaken, my understanding is that they already voted it to choose between 2 ordinances, both of which remove the buffer in one way, shape, or form, but they have not voted on which ordinance. I don't know, maybe you can correct me if I'm wrong in that understanding. I wanted to respond to something you said earlier, which was regarding a potential priority list for people who have already spent their money going through the process and complying with everything. And should the buffer be removed, you mentioned that there were about 268 people buffered out. All those people I know paid fees and inspection fees and chimney inspection fees, and you name it, they paid it. And I just wanted to underscore that I thought that was a very good idea that you all were discussing about considering a priority list for all of those who were supposed to be, especially in the priority list, and people like myself who may have been buffered out on a rough technicality and who also may have been buffered out even by people that hadn't completely complied with the ordinance as written. So I just basically wanted to underscore that and remind you that of that point that was made earlier. I think it's a good point. The other thing I just wanted to respond to in your discussions very quickly, and this is minor, you mentioned that inconsistencies between inspectors didn't come up very often, and I just wanted to point out you would only really know about that if you were a person who had two different inspectors. And it's interesting, even the second inspector talked about the first inspector and said that the first inspector was very picky and he would not have done what she did. So I think that that's a real point, that there were inconsistencies. I think it's kind of like mice. You see one mouse and you say, we don't have a problem, we only have one mouse. But there's a whole bunch of other mice that are reproducing behind the wall. And so even though you've only seen it, I do think it is worth later at some point when they get to the point of refining the guidelines. I like a lot of your suggestions that, maybe people use a template. I like the suggestion that, potentially some training goes into it about inconsistencies and, making sure that the ordinance is being interpreted the same. That it shouldn't be an advantage to get one inspector over another. That's not a fair process. It should be that no matter who you get, you're being treated the same. And the very last thing I just wanted to say is, there's a luck of the draw in which inspector you get. You could get the same inspector twice, or you might get two different inspectors. And I just happened to be one of those people who had two different inspectors and got to see firsthand that it was a different experience with each of those. So I just wanted to say those things in response.
Thank you very much, Ms. Jackson, for sharing that.
There are no other raised
Okay,
hands.
thank you. Okay, so now we will go on to updates and announcements from staff.
Next scheduled planning commission meeting is February 19th, and we do have a packed agenda.
Thank you, Mr. Hitchcock. Let's see, my announcements. First would be to welcome Commissioner Gonzalez. Thank you for your service on this commission. Very happy to have you. I'll speak on behalf of staff. The next announcement is I think an important one. It's something that we announce to every time we have a new commission, which in this case we have one new member, but some incumbents that are returning. And I'm not sure everyone's had a chance to attend this over the past, but there is a Cal Cities Planning Commissioners Academy that is conducted every year, and it is from March 11th through March 13th. And we always like to extend this invitation for any commissioners, whether they be new or well seasoned, to attend this academy. And it's pretty good. It expands kind of the knowledge of what the role of commissioners are. It gives updates on, kind of the basic legal framework of what a planning commissioner does, and discusses some kind of emerging topics. And this year it's in Anaheim, California. The deadline to register is March 4th. However, it does fill up. So, as we extend this invitation to the commissioners, if you are interested, please reach out to staff, and we can work to get you signed up. And there's budget for it. So the city, much like for any kind of training, the city would cover like basically your the travel and the registration associated with the training. So I just want to extend that offer. Excuse me?
And the hotel room too?
Yeah. It would cover like the registration and the hotel. It's at the Sheridan Park Anaheim Hotel, and it's from March 11th through March 13th. I've always heard good feedback from commissioners that have attended this. It's put on by the California League of Cities. So reach out to us if you're interested in attending.
Thank you.
I just also want to welcome Commissioner Gonzalez.
See, we'll go on to Planning Commissioner reports and comments. Anyone?
And I'll just point out, this is the section where if you want to add a standing item for the VHR discussion, we could do so.
Is that by motion?
That would be, it would be a first and a second, yeah.
Any comments from anyone first?
I'd like to add this on to, for the next couple of meetings as a standing commission of the VHR, suggestions and reports.
I'll second.
And by the next couple, so the next 2 meetings, or do you want to set a specific
I think
amount?
we should just have it as a standing item.
Until we choose to get rid of it.
Yeah, let's, I'll make it a standing item till we decide to remove it.
I will second.
Good idea. I love it.
Okay. Welcome, Ms. Gonzalez. We're glad you're here.
Thank you so much. You all gave me 2 doozies to start with. So I watched past meetings.
Welcome.
These ones were technical. So thanks for having me.
Thanks for all your input.
On technical, thanks for our IT and our clerk's office for getting us back on track after that would have taken, I thought that was going to take a lot longer. So good work. And welcome back, Dan.
Okay. With that, we'll go ahead and adjourn the meeting.